Calling State of Wisconsin versus Maxwell Anderson, case 24, CF1692, appearances.
Megan Newport and Ian Vance Curzan appear for the state along with Detective Joanne Donner, who's at council table.
Attorney Anthony Cotton with Max Anderson, Jason Finling as well. Good morning, Judge.
Good morning. Good morning, everybody. Good morning. So welcome back. Just a couple of reminders. Remember, if you need to stand up, feel free to stand up. Go, if in the back row, stand right where you're at. If you want to come to the side, if you're getting a little antsy, feel free to do that over here. Remember, no talking in the box. You can't communicate with each other and relative to anything to do with the case until you're in deliberations in the back, the final 12 of you. So no talking in the box as well, okay? We are still on the state's case in chief. The state, are you ready to call your next witness?
Yes,
Please do so.
state calls Chloe Wright.
Ma'am, if you could just remain standing and raise your right hand. Do you solemnly swear that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
If you can please be seated, state and spell your name for the record.
Chloe Wright.
CHLOEWRIGHT.
Ms. Wright, you can actually pull that microphone towards you instead of leaning into it. Thank you. How old are you?
I'm 24.
Do you know somebody named Maxwell Anderson?
I do.
Do you see him in the courtroom?
I do.
Can you describe where he's sitting and what he's wearing?
He is at that left side table to me in a blue button down.
I'd ask the record to reflect the identification of the defendant.
Any objection?
No.
The record will so reflect.
How do you know the defendant?
We dated previously.
When did you initially meet?
May of 2021.
Is it fair to say that you met through work?
Yes.
How long were you in a relationship with the defendant?
We started dating the end of 2021, so I'd say December, and then ended things, I'd say March of 2023.
Were you familiar with where he lived?
Yes.
Do you know the address?
3161 South 39th Street.
Had you been to that residence
Yes.
frequently?
Yes.
Can you describe some of the things that you and the defendant would do while you were dating, just in general?
We would hang out at his house a lot, and then we'd go to different restaurants or bars.
Was there any particular place that the defendant shared with you that was unique or special?
He wanted to show me this like secret beach that he described it as, just being like a really private area to hang out.
Was that his word, a secret beach?
Yes.
And when did do you remember when he first took you there?
I want to say that first spring that we were dating, so that would have been spring of 2022.
How many times do you think he took you there?
I'd say between 5 and 10 times.
And can you describe, do you know where it was?
I know like how to get there.
Okay. Do you know if it had a name?
I do now of Warnemount Park, but at the time I did not.
Okay, at the time that you were dating him and he would take you to this beach.
Correct.
Why didn't you know the name of it at the time?
He would always just call it like the beach, and he had mentioned he didn't want me to know the name of it in case we broke up. He didn't want me taking other people there.
Did he describe this place to you before he took you there?
Just briefly about it being like really private. Not a lot of people go there. It's just a little like private beach.
I'd like to get into some more details about the beach a little bit later, but just in general, what did you do when you were there with him?
At the beach, we would generally, he'd bring his dogs, and then we would just hang out, build a fire. Sometimes we brought snacks, sometimes I brought a book.
Going to show you Exhibit 295 and ask you if you recognize what I'm showing you.
Yes, this is the beach that we would go to, and then his 2 dogs.
That's a photograph, correct?
Correct.
This is not a photograph that you took.
No.
I'd move in 295 and ask permission to publish.
Any objection?
Yes, she didn't take the photo.
If she's identified it, the photo is of what it purports to be, the authentication's in place. I am going to receive it, you may publish.
Are those the defendant's dogs?
Correct.
And that looks like where he took you.
Yes.
At some point, you contacted the Milwaukee County Sheriff's Department, correct?
Correct.
Do you remember when?
I want to say it was April of 2024.
Okay, after you were aware of Sade Robinson's disappearance?
Correct.
And was this after the disappearance?
Yes.
And why did you contact the Sheriff's Department?
Well, I contacted them after the disappearance and after the news was released that he was in custody under suspicion of this. And I contacted them just because I knew he was a pretty secretive person with like his house. So he would buy like shelves with false backs or have these like hidden compartments. Like there was one in the bathroom, like under the sink, that he would place a piece of marble in and it would blend so you couldn't really tell that there was a compartment under there.
So that was something that you're describing in his bathroom at 3161 South
Correct.
39th Street?
Yes.
Is that something that you saw?
Yes.
Where was it?
In the bathroom underneath the sink.
Okay, underneath the sink, did the sink have like a vanity?
Correct. So the vanity was this marble color, and then there was the sink with the cabinets, and then there was like a spot underneath the cabinets, probably 3 or 4 inches tall, and he would just stick a piece of marble that matched the vanity there so that it looked like it was one piece.
Going to show you what's been marked as Exhibit 496.
Thank you.
Do you recognize what this is?
Yes, that is his bathroom.
It's a photograph, correct?
Correct.
Okay. Can you, I'd ask that 496 be received.
Any objection?
No.
It's received.
Can you draw on there where the secret compartment is?
Is it showing up or do you need a Sharpie?
It's okay. Just not.
Thank you. Permission to publish?
Go ahead.
Okay, so this is the vanity, correct?
Correct.
And what you drew in this kind of blue rectangle in pen is what?
It is the piece of marble that he would be able to slide in and out of underneath the vanity. So it does match like the top of it, so it would look as one piece.
And that's something he showed you?
Yes.
Was there anything else similar to this inside that residence that you were aware of?
He did have a closet in the living room area that he would cover with an entertainment center, so you weren't aware that there was a closet behind there.
And you felt that at least some of this information was important to tell law enforcement, correct?
Yeah, I mean, I knew they were searching the house. I just have no idea how extensive these searches are, so.
Did you also share with law enforcement the information about the secret beach?
Yes,
Did there come a time a few months later where law enforcement was back in contact with you about that location?
yes.
And what happened when they were back in contact with you?
Well, the first time I had mentioned it, I had just said that we had been to a beach, looked very similar. I wasn't sure of if it was the same one, and then they had reached out again several months later, and they were like, do you know if it's
Objection hearsay.
It does call for hearsay, I'll sustain that.
Did you ultimately meet with law enforcement?
I did.
And did the particular detective or officer that was with you actually go with you to the location?
Yes, I directed them.
Okay. Do you remember where you started out?
Yes, I remember that we would take Layton pretty much all the way down. So I had them get me to Layton, and then I was able to direct.
And when you say we would take Layton, who are you referring to?
Maxwell and I.
Would you say that you have a good knowledge of the city of Milwaukee in terms of directions and different roads?
No.
Was there a particular landmark that you identified that you were able to direct law enforcement to get you to this location?
Yes, so I know we would take Layton all the way down, and then on the way there, there was a Mexican restaurant, El Beso, on Layton. So that was on the right-hand side. We would stop there sometimes before going to the beach. And then I knew that the airport was, you'd have to pass the airport, so I could tell that I was going in the right direction through those landmarks.
And you did this same route with the sheriff's department?
Correct.
Going to show you exhibits 265 through 277, and just to yourself, look through those and let me know if you recognize what they are.
Individually or just?
Individually, yes.
Okay. Yes, this first one I do recognize. It looks like where we would park to walk to get there.
But do you recognize, sorry
Oh,
if I was confusing.
no, that's okay.
Do you recognize all of those
Correct.
exhibits? that
This is
Okay,
the beach that we would go to.
okay. I'd ask for exhibits 265 through 277 to be received and published.
Any objection?
No.
They're received, you may publish.
Showing you exhibit 265. What is this?
That is where we would park our car, and then that fence there is where we would enter to get to the beach.
Okay, so would you park your car down here or in this,
In that dead end spot.
down where the car is?
Correct.
Exhibit 266, do you recognize this?
That is the fence that would need to be gone through to get to the beach.
Was that-
However, it looks like that was a replacement. That doesn't look like the fence that we would go through.
Okay, so that looks like a different fence versus when you were there with the defendant.
Correct.
Showing you exhibit 267, what is that?
That is the fence that we would go through. There was that gap in between the two connecting fences, and we would squeeze through there to get to the beach.
What is 268?
After we went through the fence, there was like a really long paved hill that we would have to go down. So that looks like that.
Once you went down the hill, which direction did you go?
Left.
And what was down at the bottom of the hill?
Down at the bottom to your right is this building. I'm not sure what the building is. And then to the left, it was pretty rocky. And then once you got past the rocks, you would get to sandy area, which was where we would hang out.
Did you ever go to the right with him?
No.
Showing you exhibit 269, what is that?
Just an extension of the hill. It was pretty long. So then if you just continued down to the left, there would be the beach.
Is this the building that you talked about?
Correct.
And you would go this way.
Yes.
Exhibit 270? What is that?
Same thing. That's just a different angle of the building.
Describe, when you go to the left, how you get to the beach.
So we would either go, it was pretty rocky, so we would either climb kind of through the rocks, or there was, if you, like a little bit longer of a way, there was like a back trail that you kind of had to go up and around, and it would get you past the rocks.
Which did you prefer to navigate?
Usually the trail, because I would be wearing sandals, so didn't want to cut my feet on the rocks.
What about the defendant?
He'd usually take the rocks, depending if we had the dogs or whatnot.
Exhibit 271, what is that?
Those are the rocks that would need to be climbed over.
272, what is that?
Just another angle of the rocks. Further past those trees would be kind of where that trail that I would take is.
What about 273?
So there's a better view of the trail.
Can you stand up and point to where the trail is?
If you're going to talk, there's a microphone right next to you that you can turn on if you need to talk.
Okay, so the pavement kind of goes down this way. You would enter through, it had all these fallen down trees, so either route was dangerous, I suppose, but the trail kind of curves through this way.
Once you got down to the beach, how far down would you walk?
From when you get there and you can visually see, because it kind of goes around a bend, so from what you can visually see, we would go about halfway down. There would be a fallen down tree over there, so there was like lots of bark and stuff, so we'd usually park our blanket by the fallen down tree, because then we would use that fallen bark to build our fires.
Showing you exhibit 275, what is that?
That is just an extension of the beach. I believe that we would usually put our blanket right about here.
Exhibit 276, what is that?
So when we were at the beach, behind us, this is what it would look like. It wasn't just like a big open plain, it was just that little strip of beach, and then this wall behind us.
And exhibit 277, what's that?
Just a view from the beach from the opposite angle, so going towards the pavement.
When you met with the sheriff's department, did you provide them any photographs that you had of either you and the defendant, or photos of this secret beach?
I did.
I'm going to show you exhibit 278 and 279 and ask you if you know what they are, and I can take this from you.
This is a photo that I took when we were at the beach.
Okay, and you're referring to 278.
Yes, and then 279, since it was taken on Snapchat, I had to press and hold it to where it would show you the location and the date and time.
So those are screenshots from your phone,
Correct,
and 279 is kind of an extension of 278?
correct.
Okay, I'll take those. I would ask for 278 and 279 to be received and permission to publish.
Any objection?
No.
Received and go ahead.
Okay, we're looking at 278. What is that?
So you can see my beach blanket. I'd keep that in my car for when we would go. And then that was just a fire that we had built.
And does 279 tell you what date that photograph was taken on, or what date you posted that on Snapchat?
It does. That is the day it was taken, May 12th, 2022, 6:10 p.m.
Does it give a location stamp too?
Yes, Cudahy, Wisconsin.
I don't have anything further.
Cross?
Good morning.
Morning.
So as I understand it, you and Max dated for about 2021 to 2023, give or take about 2 years, you'd say?
Correct.
Not through work, obviously, right?
Correct.
And you would hang out at his house. Did I hear that correctly?
Yes.
So you knew where, you even knew his address, obviously, you just said it, right?
Yes.
And that was a place where he would take you and you would watch TV or spend time together there, right?
Correct.
And you've talked a little bit about this hidden compartment was it in the bathroom area?
Yes.
And actually, the reason why that's important is because when after you heard, I mean, obviously you heard the news about Max being arrested and suspected and all of this, right?
Yes.
That's sort of what prompted you reaching out to law enforcement.
Correct.
So it wasn't until you had seen things in the news that you actually initiated contact with the police, right?
Correct.
And the first thing about that secret spot in the bathroom, you wanted to make them aware of that because you knew law enforcement was going to go search the house, obviously.
I didn't know if it had been done or not at that point, but I just wanted to make them aware.
You suspected maybe they would search a house in a situation like this, right?
I suppose.
Right, you wanted to make them aware of, hey, there's this secret spot here. If you do search the house, this is where it is, right?
Yes.
And that secret spot was something he had shown to you, right?
Correct.
Because you guys trusted each other, or at least he trusted you.
Correct.
And that secret spot was for purpose of hiding basically money or weed, right?
Yes.
Okay. And this beach, you guys have gone there a handful of times together, right?
Yes.
Do you have any idea, so you didn't know the name Warnemont Park back in 2021, 22, or 23, right?
That's correct.
You know it now because you've heard the articles, right?
Yes.
Have you've read a little bit about the situation or the case?
Yes.
I mean, it's of particular interest to you, obviously, because this is an ex-boyfriend of yours, right?
Correct.
And you broke up before he was ever charged in this case. You broke up in March of 2023.
That's correct.
So a year before anything had allegedly happened, you guys were already broken up, ex-boyfriend, ex-girlfriend.
Yes.
Not one of these situations where people are still sort of keeping in touch with each other and maybe dating other people, broken up, right?
Correct.
And you hadn't even seen Max for over a year since you broke up, right?
That's correct.
In fact, you never saw him from the breakup until he was arrested. Right?
I believe I had ran into him at a concert that summer, but we didn't hang out at the concert or anything. It was more like a, hey, how are you? Move on.
The dates that you went on, I don't need to go into all the details, obviously, but things like going out to dinner or going to the movies or going to a beach, is it things like that?
Correct?
And he was never physically abusive, was he?
No.
And you were aware that at his house, he even had someone living below at his house, right?
Correct.
You were familiar with the layout of the house. He even told you about the spot in the living room where the desk was there and there was the closet, right?
Correct.
And just going back to this beach, obviously you didn't know the name back then, you said, didn't know that it was called Warnemont Park, right?
Correct.
So in terms of hanging out there, did you ever hang out there with other people, or just that's the spot you and Max had gone?
It was just Max and I.
So in terms of the number of, and how many times did you estimate you went there with him?
I said between 5 and 10.
So just a range, right?
Correct.
And the pictures you've shown are the only ones that you had taken there, the picture of the fire and the dogs on,
Yes.
the ones of the dogs on the beach, you didn't take that, right?
No, I did not.
You recognize those dogs as being Max's dogs, right?
Yes.
So when you would go there, you would take, you said Layton Avenue past the airport, right?
Correct.
Right into the beach.
Yes.
And not College, right?
No.
And there's a Mexican restaurant, El Beso. The two of you would stop there periodically as well, right?
Yes.
And what you would do at the beach is just hang out there and spend time together like any other couple might do, right?
Yes.
He never told you, don't tell anybody about the beach. He just didn't tell you the name.
Correct.
And to get down there, there's a path around the side of the fence. So I think you said the route that you would go would be to walk around the fence and then walk down, right?
Yes.
Never drove a car down in that area, right?
No.
And the beach is, the path down to the beach, there's sort of a walking trail that you would take sometimes, right? Is that what I heard you say before?
Yes.
What is the terrain of the walking trail? Is it paved, or is it just, would it be described as a muddy trail that goes down?
It's muddy. It's pretty worn out too. So it's not really like actually muddy, but it is dirt.
It's dirt, right?
Yes.
Had you ever gone there with Max when it was raining and muddy?
There were times where we had been there and it had started to rain and we would just leave right away.
Not any time where it had been pouring and pouring like that, right?
No.
So in terms of the dirt path, and the dirt path is the one you would take, there's also some other ways through the woods you can walk down there? Or no?
I'm not aware of any other way through the woods.
Just the dirt path.
Correct.
And then there's sandy beach, right? You said there's a rocky part of the beach and a sandy part of the beach.
Yes.
Max never told you get rid of any photos or anything like that, right?
No.
And in fact, after Max had been, in early April, let's say, April 1st, April 2nd, April 3rd, did Max ever reach out to you?
Not in April.
Okay. In April, he never contacted you and said, get rid of some photos of the beach or anything like that, did he?
He did not.
Or tell you to, or even try to make contact with you at all, right?
Not in April.
Right. That's all. Thank you.
State, do you have a brief sidebar before redirect? Sure.
I'm going to excuse the jury for a moment. You leave your notebooks on your chair. Okay, State had just requested a sidebar. I thought it was easier just to handle this on the record. State, why don't you restate where we were at?
Attorney Cotton asked a question as it relates to whether or not the defendant was ever physically abusive with Ms. Wright. Her answer was no. So while I expect Attorney Cotton to argue that that was a narrowly tailored question, I think the broader inference is that he was eliciting that Mr. Anderson is not physically violent. That information about never being physically abusive is in the report, followed by information about how Ms. Wright reported that he was emotionally abusive towards her, that he would make fun of her and call her names. And then there was also an incident with one of Ms. Wright's ex-boyfriends, who she names, and that he would constantly get angry. Mr. Anderson would get angry with her over this individual, and that at one point they got into a physical fight, this being the ex-boyfriend and Mr. Anderson at a specific bar with an address given on a specific date, that the police were never involved, but Anderson and this ex-boyfriend were removed from the bar. She also reported that at one point the defendant told her to invite the ex-boyfriend over to her residence and asked her to beat herself up in the bathroom and to call the police to get this individual arrested. So, I mean, I've got concerns that the defense question
was clear to the police that he was never physically abusive with her. I stopped with that question and explored nothing further. The reason I explored nothing further, Judge, is because I understand that if I start drawing broader inferences, of course, if I start speaking more broadly about, well, therefore he has a character trait of peacefulness, he was never abusive with anybody, he never, then I'm going way beyond the question. I get that. So I tailored it to ask only what she had told the police, that Max was not physically abusive with her. How that opens the door to other acts evidence of his behavior on another date of telling her to beat herself up, which as I understand, she never did. And again, it was a statement that he made. I really disagree. I was precise with how I asked that question to elicit only that answer. And I asked no further questions about that topic at all, about his abuse with her.
State, what is the statute you're relying on for the path of admissibility relative to specific instances of conduct? And defense, is there a statute you're relying on as to why it is not admissible?
Why
Why it should not be
it's yes.
under 90404, are you looking at?
90404 for sure.
Is there anything else?
Yes, because primarily because it would constitute other acts evidence to get into other occasions when he told her to beat herself up or when he was emotionally abusive. And I think with all due respect, there's a drastic difference between emotional and physical abuse, without a question.
Judge 90405, and again, this was not something that the state intended on eliciting. In fact, we had a conversation before this witness came up where I indicated the scope of what I was going to ask her, so we wouldn't even come close to this type of information.
And that conversation was not held on the record or with the
No,
court? It was held between the parties? Is that correct?
It had nothing to do about any physical anything, though, to be clear.
Then if the purpose of that question is not to elicit character information of him not being a violent person, or that she would have no reason to be scared of him, what's the purpose of that question?
You can answer that.
So, yes, the purpose of the question was to make it clear that he was never physically abusive with her. It was not to suggest that he has a character trait for peacefulness, or that he has a character trait for nonviolence more broadly. That's why I didn't ask her anything about broad character traits. And typically when we get into, if the state's arguing character and habit evidence, typically the way we prove that under 90405, as you know, Judge, is reputation or opinion coupled with specific instances of conduct where it's noticed up and it is disclosed if the state wishes to go into it.
Right, I don't think they were going into it. I think that they're claiming that you, by interjecting your question, went into character evidence, and now they should be permitted to go into specific instances to rebut.
I understand the argument. I never asked her, I'll rest on my arguments with all due respect. I never asked her about Mr. Anderson's character trait. Typically when we talk about character traits, we ask a witness, does this individual have a character trait for X? They say yes or no. Are you familiar with their character trait? Yes. And then how are you familiar with it? Well, this is why, and they answer the question. If the state wants to, I certainly think if they want to ask her some rebuttal about his physical abuse to her, if there was a time when he physically abused her, that would be appropriate, but I don't think there was any physical abuse towards her. And I wasn't asking about character traits more broadly.
So looking at this matter, what it comes down to is, did the defense, by asking the question to the words of the effect of, did the defendant ever physically abuse you? Did that basically have the defense putting into evidence a pertinent trait of the accused character offered by an accused? Clearly, the implication of the question would be that he was peaceful and that he'd never engaged in physically abusive conduct to Miss Wright. state's argument is that the inference to be drawn and the question's basis was greater than just, did he physically abuse you? But also, does that put into place his character of him being nonviolent or peaceful? Looking at our statutes and looking at 90404, character evidence generally, this isn't a situation where the state sought to introduce evidence of other crimes, wrongs, or acts under 90404 sub 2. And what I've been told is that the state affirmatively told the defense they were not going into that area during a conversation off the record in anticipation of her testimony. The defense asked the question, which I would take it the state's argument would be that by asking her that question, it's forming an opinion on her behalf as to him being nonviolent. The statute goes on under sub 2 to indicate relative to specific instances of conduct in cases in which character or a trait of character of a person is an essential element of a charge, claim, or defense. Proof may also be made of specific instances of the person's conduct. So is the defendant being of a peaceful character an essential element of the defense? And I would think it is. I would think it's part and parcel of what the defense is going to argue in this case. As to specific instances of the person's conduct, the state has indicated that they're aware of 3 different prongs. The first prong would be that the defendant was emotionally abusive. The second prong was that he engaged into an altercation with her ex-boyfriend. And clarify for me, was Ms. Wright present at that altercation or was she not? Or is this just something she's heard?
We could ask her.
It's unclear from the police report. She is
Right.
still here.
We
I
should
was
ask
getting
her.
there. I just thought the state might know.
I was present.
Okay, so she was present, so she would be a competent witness to testify as to what she observed. And as to the third situation, did that post-date the fight or predate the fight?
Post.
And then afterwards, the second situation where she was asked to have the ex-boyfriend come to a location and where she was asked to beat herself up and then blame him and contact law enforcement. Did I get that fact pattern basically correct?
Yes.
Those would be specific instances as to prongs 2 and 3 of a nonviolent character. I will agree with the defense that I think that at time, well, I guess I agree with both sides as to whether it being emotionally abusive, at times that can rise to a level of being indicative of not being peaceful without a doubt. But it also, on the other hand, is different than physical abuse. So relative to our statutes, I am going to find that the defense has placed into play character evidence by the question, and I understand that Attorney Cotton indicated he knew what he was doing, but I also think Attorney Cotton's smart enough to know he was drawing at that line by asking that question, knowing in advance that the state wasn't going down that path. And I am going to find that the defense has opened the door by putting in play the character evidence of the defendants because it is an essential element of their defense. And that based on that, they put into play that he is of a peaceful character. I'm not going to allow the state to go into the emotional abuse. I think that that's at a different level than what's already been indicated here. And I think that that would create a whole separate issue. I will allow the state to go into the two specific instances of conduct to rebut the character evidence that the defense has put into play relative to her observations of a bar fight, as well as the conversation to have her beat herself up and to have the boyfriend come over and then to report it to the police. I am going to find that that is allowable pursuant to 90405 sub 2. Any questions relative to my ruling, state?
Yeah, I think Attorney Vance Krazan and I were just chatting about making sure we have a very narrow scope of the questions to be asked. So I think we're going to ask her if she had observed any specific instance where the defendant was physically violent with someone, who that person was, when that was, and where it was, and we'll let it lie there.
Okay, thank you.
Understood. Anything further to address on the record before we bring the jury back?
No, I would just ask if Ms. Wright understands the scope of what I just described.
Ms. Wright?
I do.
Okay.
Okay, thank you.
It's my understanding that the stream of the trial did catch some of the jurors as they were exiting. I would ask the media to be cautious. My court order that was issued in advance of this indicated no filming of the jury. So please be on top of that moving forward, or else we might be changing up the present state of affairs. Understood? Okay, I got a thumbs up. Thank you. Is there water with your victim witness person? The witness just asked if there was water, and it appears she's getting that right now. And if not, I probably could grab some in back. Okay. State, please proceed.
Ms. Wright, on cross-examination, you were asked a question about whether the defendant had ever been physically abusive towards you, correct?
Correct.
And your answer was no.
Correct.
Do you recall telling the sheriff's department about a specific instance where you saw the defendant be physically violent with someone else?
Yes.
Who was that?
A previous ex-boyfriend before Maxwell.
And where did that occur?
That occurred at Trinity on Water.
That's a bar
Correct.
in Milwaukee?
Correct.
And what happened? Were you there?
I was there.
What did you see?
It all happened very quickly. I turn around 1 second and Maxwell and my ex-boyfriend were fighting. I don't know exactly how it was initiated. And then I just remember both of them being on the ground, and then the bouncers broke it up pretty quickly and kicked them both out.
Do you remember what day that was on?
I want to say it was St. Patty's Day of 2022.
When you talk about fighting with each other, was this a fist fight? Can you further describe?
Yes, it was a fist fight, and then it was so quickly, I think maybe like 1 or 2 punches were thrown, and then they were kind of just wrestling on the ground.
Okay, I just have one final question about the secret beach. When you would go there, were there other people around?
Not usually. I would see maybe one person walking their dog and passing by, but there weren't other people hanging out there.
Nothing further.
Cross.
Yes, thank you. So was not a situation where Max attacked, not a situation where Max attacked you at Trinity, right?
That's correct.
And you said 2022, so that means it was when you were dating him.
That's correct.
So you and Max were dating, and then an ex-boyfriend showed up to Trinity,
That's correct.
your ex-boyfriend.
Yes.
And actually, it was the ex-boyfriend who actually started it, isn't that true?
I don't recall who started what.
Do you recall when you were interviewed by, well, you do know that you sat down with law enforcement and talked to them about Max, right?
Yes.
You sat down with a sheriff's deputy, right?
Yes.
And you described that there was a fight on St. Patty's Day. You remember telling them about that, right?
I do.
But you don't remember telling them that was your ex-boyfriend was Jack, right?
That's correct.
And you said, do you remember telling them Jack actually started it and then Max got him in a headlock? Do you remember saying that?
That is possible that I said that.
Well, that's what happened. The ex-boyfriend Jack started it. He showed up, you were dating Max, and Max got him in a headlock, right?
Okay.
Okay, and then security broke it up.
Correct.
Thank you. That's all.
State.
Did you just respond by saying okay because you didn't know the answer to what Attorney Cotton was telling you?
If that is what I said, then that is what I said. But at this point in time, I don't remember how the situation occurred.
I don't have anything further.
No,
Attorney Cotton.
no, Your Honor.
Thank you. You may step down. State your next witness.
State calls Detective John Galat.
Do you solemnly swear that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
If you could please be seated, restate and respell your name for the record.
Detective John, John, Galat, Guillot.
You're a detective with the Sheriff's Department, correct?
That is correct, yes.
In April and then July of 2024, did you have contact with somebody named Chloe Wright?
Yes.
And what was the nature of that contact?
Through the investigation, it was learned that Miss Wright dated Mr. Maxwell Anderson. I believe she indicated that the two.
I'm gonna further direct a question, a more pointed question. Did she provide you with information about a secret beach that she would go to with the defendant?
That's correct, yes.
Okay, and was she able to describe where that was?
Yes.
Was she able to give you a name?
I'm going to object to hearsay. We had the witness testify.
Any response?
It's going to go to the effect on the listener as to why he did what he did.
If it's not being offered for the truth of the matter, it's not hearsay, you could answer it.
She indicated that Mr. Anderson never disclosed the park's name just in case the two ever parted ways.
Was she able to describe the route to get to that park?
Yes, she was.
And did you in fact take her on that route?
Yes.
Can you describe where you started and where that route led you?
Yeah, I believe it was July 10th, 2024. Myself and Deputy Ethan Stouts met up with Miss Wright at her residence. She got into our vehicle and then she directed us to the route to the park. We started by traveling southbound on I-43 from Capitol Drive. She directed us to Layton Avenue. Once we got off of Layton Avenue, she directed us eastbound on Layton Avenue. Of note, she pointed out a Mexican restaurant, I believe it's called El Beso, which is located at 909 West Layton Avenue. She indicated that prior to Mr. Anderson and her going to this quote-unquote secret beach, that they would often stop at this restaurant, have drinks, have food. Past that, she directed us to continue on eastbound till West Sheridan Drive. From there, she directed us to go southbound on Sheridan Drive to West Pulaski Avenue.
And then what?
She pointed out a fence. The fence was, I believe it said do not enter. And then she indicated past that fence is where this so-called secluded secret beach was.
Where did she lead you?
So she led us.
And actually, like, is there a name of where she led you?
Yeah, it's essentially Warnemont Park.
And then did she lead you further?
Yeah, so once you get to this fence, you have to squeeze through the fence, and there's a paved area which descends down to the secluded beach.
Had you ever been there before?
I have never been there, no.
Were you aware of members of your department who had been there as it relates to an investigation into the disappearance of Sade Robinson?
Yes.
What else did she show you?
She showed us kind of the area where they would hang out. She noted that they would often have fires on the beach, and she indicated specific locations on where on the beach they would usually sit.
Are you aware that as to whether or not this location is where generally Sade Robinson's leg was found?
Yes, that's correct.
That is where it was found?
Correct.
When she was leading you down to the beach, did you walk past what you know to be the Cudahy Water Department pump house?
Correct.
Nothing further.
Cross?
No.
Thank you.
Thank you.
State?
Detective Mason Collat.
Do you solemnly swear that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
If you could please be seated, state and spell your name for the record.
I'm Detective Mason, Mason. Last name is Kohlhapp, Kohlhapp.
Are you a detective with the Milwaukee County Sheriff's Office?
I am.
How long have you worked for the Milwaukee County Sheriff's Office?
9 years, and I've been a detective for 4.
Did you assist in the investigation to the disappearance of Sade Robinson?
I did.
Was one of the roles that you assisted to review a phone extraction of Maxwell Anderson's cellular phone, a Samsung phone specifically?
Yes.
I'm going to show you an exhibit. It's already been entered into evidence as Exhibit 264. Can you take a look at that and tell me if that's the phone extraction that you reviewed?
Yes.
And describe briefly, if you can, how you received that.
Detective Vandertine and I went to DCI. We both picked up the phone, or I should say the actual download of the phone. We brought it back. Matt then uploaded it to evidence.com and then provided me a copy of that phone.
So what you were reviewing was the extraction that DCI had pulled off of that Samsung.
That is correct.
What is DCI, if you could just clarify that briefly?
It's a state agency. It's Department of Criminal Investigations.
What were you looking for? What was the purpose behind going through this?
To look for any evidence pertaining to the owner of the phone, along with the anything with the disappearance of Sade.
Do you recall what date you went through that phone extraction?
I believe it was April 9th, 2024.
And her leg had been found on the 2nd, right?
I believe so, yes.
Did you prepare some reports through any kind of computer program that you used to go through the phone?
Yes, when it was handed, or when I was provided the copy from Detective Vandertine, it came on 2 different, I should say, it's not necessarily reports, but phone reviewing systems. One is Celebrate, and the other one is Axiom, is how they take the phone, they download it, and it's just put into 2 different programs so we can view the contents of that phone.
So you have multiple different programs that are used to essentially look at the contents of the phone?
Yes,
And you use 2 of them?
correct.
What were they again?
Axiom and Celebrate.
Can you spell those?
Cellbrite and Axium, I believe.
I'm going to show you a few exhibits here. The first one is Exhibit 444. Do you know what 444 is?
This is a Celebrate, and this, the end result of the Celebrate is usually put into a PDF form.
How many pages is it?
7 pages.
And is it contain certain information about that phone?
Yes.
Okay. I would move Exhibit 444 in.
Any objection?
No.
It's received.
Can you tell us from Exhibit 444 what the phone number assigned to that cell phone was?
Yep. It's 262-416-4874.
I can take that one from you, and I'm going to ask you to page through 296. Take a moment to do that, and then tell me when you're done.
Okay. Okay.
Do you know what 296 is?
Yep.
And what is it?
296 is my extraction report from both the Celebrate and Axiom.
Move 296 in.
Any objection? No, Your Honor. 296 is received.
So you already discussed that you had identified the phone number that belonged to that device, and did you learn that that was the phone number that Sade Robinson was last texting with?
That is correct.
When you went through that phone extraction, were you able to locate the text conversation between Maxwell Anderson's phone and Sade Robinson?
That is correct.
I'm going to show you 287. What is that?
This is the Celebrate report that contains the text conversation between Sade and Max.
Was that the entirety of the text conversation that was on the device?
That is correct.
Move two, I'm sorry, what number was it? 296?
287.
287.
287? Not
Any
even close.
objection?
No.
Received.
I have 287 up on the screen. There are multiple ways of looking at text messages in these Celebrate. It should be loading soon, hopefully. All right, is that 287 up there?
It is.
There are multiple ways that you can view text message conversations on Celebrate, right?
Correct.
Would you say this is probably the easiest way to do so?
By far, yes.
Why is that?
Because it shows the send and receive from both phones compared to other ways you can do it where it's a lot more information heavy, but you got to look at each individual text itself. So this has the full conversation as it would appear on your phone.
Not sure why this isn't working.
I know this morning, the IT person was here doing some work before we started to make sure it all ran smoothly. It doesn't seem that that worked. We'll call him right now and have him come back directly. Is he on his way? Well, it's 9:53. Do you need a break real quick, a bathroom break, anybody? No? Okay. And we're in a holding pattern for a minute, I think.
All right, I'll use the paper one. No, it's not coming up at all.
You can't change it back over to the Elmo now? I've just received information that the IT person's on his way right now.
Okay, well, I can't get either of them to work at this point, so. All right, here's what we're gonna do, Detective. The text conversation, why don't you just go through it orally? Tell us, when does the conversation start between Maxwell Anderson and Sade Robinson?
So on this first, it's a blue. I'll show, is that all right to show?
Sure.
Okay, so this is where the conversation starts. It's a blue. It was created on 3/30 of 2024 at 6:33:10 a.m. UTC. So with the conversion, it'd be approximately 1:30 in the morning is when the text conversation started.
On what date?
The 30th, I believe.
Okay.
March 30th.
And were you aware that they went to the Twisted Fisherman on April 1st?
Correct.
So this was just 2 days prior?
Yes.
And what time in the morning?
1:30. 1:33 to be
And-
specific.
How does the text conversation begin?
It says the first text was to Sade, and it says Maxwell. And then the follow-up one is Sade responding to Sade.
Exchanging their names
Exchanging their names, correct.
at 1:30 in the morning on basically a Friday into a Saturday.
That is correct.
When is the next text?
The next text is also on the 30th, March 30th. It's at 2:30 in the morning. And it says, "Hey, love, I left my comb there."
Who sent that?
That was from Sade. So Sade's in the blue, Max is in the green. A follow-up text after that one, sent a little bit after that, within 35 seconds estimate. Can you just take it and give it back when you get a chance?
Sade asking him for a comb that she left somewhere.
Correct.
Okay, after that?
After that, Max responded with, "Of course, I'll bring it on Sunday," and that was sent at 3:40 in the morning on March 30th.
Implicit that there was a plan to meet up on Sunday.
Objection to implicit anything.
I didn't hear you. You're,
Objection to him implying anything. He said implicit.
I'll ask you to rephrase that question.
Does it appear from that text that there was a plan to meet on Sunday?
Objection calls for speculation.
I asked from that text alone.
Based on that, based on the way the question's crafted, I'll overrule the objection and you may answer that question.
I would say yes.
How does the conversation go on?
And then Sade responds later with a thank you. This would have been that next it would have been 3:30, 2024 at approximately 10, I believe, with the UTC conversion.
10 a.m. or p.m.?
AM.
Okay. How does the conversation go on from there?
The next one is from Max on 3/31/2024 with the UTC. It says 3:05:56 a.m. with UTC is about, I would say, 10 o'clock, I believe, that night on the 30th. No problem. How is your night going? And then Sade responded, "My night is going fine. My friend is here from Minnesota."
What night of the week would this have been? If the first was Monday,
This would have been Sunday.
okay?
And then the next text message was from Sade. "We might stop there."
Does she say where, or it just says there?
It just says there. This would have been 3/31/2024 at approximately midnight.
All right.
Max responded with, "I'm here," and that would have been around 12:30 a.m. on the 31st. And that's the text conversation.
All right, give me 1 second. We're going to try to get the computer back on here.
There was also the issue with they were unable to switch it from the Elmo to the computer. Is that working now?
We're just bypassing the switching mechanism,
Okay,
and they're going to operate with one cord.
okay.
All right, I have the conversation up here on the screen now. So here's this bubble here is not actually a text message, right?
Do we need to shut the blinds? Is that a glare on that for the jury?
It may help.
Okay.
That is a lot better. Thank you.
All right, the blue box up here, these are, the blue ones that we're going to see are Sade, right?
Correct.
And this top one, is that actually a text message or is that indicative of something else?
That's, from my understanding, that's just creating the start of the chat and not actually sending anything.
So the first text, like you said, this is the one, it just says, the body of the text just says Maxwell.
Correct.
And then how does she respond?
With her name.
All right, so this would have been what date and time?
This would have been approximately 1:33 on the 30th.
And you're going off of this time that I've highlighted here?
Correct. With UTC, it was -5 at that point.
Okay, so it says 6:33, but really it would be 1:33.
Correct.
That's how all of these texts are going to appear.
Correct.
Okay. All right, and then we kept going. She has the text about the comb. She asks if she can give it back, and he says, I'll bring it on Sunday.
Yep.
All right. Let's pick up where we left off here. Let's start with this green text that I've highlighted here. What's going on?
All right, so this is page 3. No problem. How is your night going?
How does Sade respond?
She responds, my night is going fine. My friend is here from Minnesota.
This would have been Sunday. Well, tell us about the date and time.
So it would have been -5 hours, so it would have been 12:32, and I believe it would be the 31st.
Okay, so this would have been the wee hours of Sunday morning.
Correct.
And then what does Sade say?
She responds with, we might stop here.
Does Mr. Anderson respond?
Yep.
What does he say?
He says, I am here.
What does Sade respond?
She responds with, okay.
Next text from Maxwell.
I'm sorry, can I see the parties at sidebar, please? Sorry for the interruption. Please continue.
Thank you, Your Honor. All right, what is, so they have this exchange. We might stop there. Mr. Anderson says, I'm here. She says, okay. What does he respond with right here?
Drop my name at, I'm assuming it's die, but I believe it's the door if they try to charge a cover.
And what real time was this sent at?
12:33.
AM?
Correct.
On what day?
The 31st.
Sunday, the 31st?
Correct.
How does Sade respond?
Okay.
Also at 12:33?
Correct.
When is the next text sent?
This would have been 12:36.
3 minutes later?
Yep.
Okay.
Still on for later.
And Then there's a gap between that text and the response from Sade, correct?
Correct.
Okay, tell us what Sade says and at what date and time.
Sorry, I'm at work. And then it would have been 4 o'clock, 4:26 on the 31st
AM or PM?
PM.
Okay, so she doesn't respond to this 12:36 AM text until Sunday evening at 4:26 PM?
Correct.
What does she say after that?
I don't know how long I'll be here till.
How does Mr. Anderson reply?
He replies, okay, sounds good.
And then what does he say?
Want to shoot for another night instead?
And what are the dates and times of the okay sounds good and then the want to shoot for another night instead text?
Okay, sounds good is on the 31st at approximately 5:36 PM. And then the want to shoot for another night would have been at 11 AM.
On what date?
April 1st.
How does Sade respond?
Yeah, I can do today or tomorrow that's abbreviated.
What does Mr. Anderson say?
Either works for me, whichever you prefer.
What time is that?
That would have been 12:08 PM on the 1st.
Are you aware of whether the first was the last day that Sade sent any text messages?
Yes.
How does Sade respond?
Okay, we can do today. What
And-
time?
Okay.
Sorry.
Mr. Anderson responds.
That's also up to you. Any time is fine for me.
What time does he say that?
About 1:54 PM on the 1st.
And keep going.
Where are we meeting? I can do 5.
How does Mr. Anderson respond?
Mr. Anderson responds, downtown somewhere, question mark.
Sade says what?
Okay.
Mr. Anderson then says,
Broad House on 3rd.
when is this conversation happening, this exchange?
This is all still on the 1st.
At what time?
This would have been at 4:23 PM on that last Broad House on 3rd.
How does Sade respond to the question brought house on 3rd?
She's replied, perfect.
Then what happens?
Max responds with, okay, I'm going to shower quick. I'll probably get there more around 5:15. What does he say next? The next, are you hungry? I need to stop at Twisted Fisherman to pick up my W-2 from last year. We could eat there first.
How does she respond?
Okay, and yes.
What time?
4:34 PM on the 1st.
Then what does she say?
Are we eating at the Broad House or the other place?
What does he respond with?
Let's eat at Twisted. I'm feeling seafood.
What time does he send that text?
4:37 on the 1st.
How does she respond?
Yes, I love seafood.
And then what does Mr. Anderson say?
Sounds good. I'm about to leave. I'll be there soon.
Then what happens?
Sade responds, okay. And then Max responded to that with, just got to Twisted.
At what time did he say that send the text just got to Twisted?
This would have been 5:11 on the 1st.
How does Sade respond to that?
Okay, are you inside, question mark.
At what time?
5:18 on the 1st.
Then what?
Max replied with a yes, and this is the 1st at 5:18.
Is there a response to that text from Sade?
There is not.
Is there a gap between this final text where she asks, are you inside? And he responds, yes. And then the next text message sent from Anderson's phone to Sade's phone.
There is a gap.
When's the next text sent?
The next text is sent on the 2nd, 4/2/24 at approximately 10:36. My math is correct.
AM?
AM.
And by that time, are you aware of whether Sade's car had been burned?
Yes.
Was it?
Yes.
So he texts her at 10:36 AM, what?
Morning, how's work going? Question mark.
Are there any other texts in this text thread conversation?
There is not.
Did you also look through the phone extraction in an attempt to find any images that might be of interest to this investigation?
I did.
I'm going to show you exhibits 288 through 293. You page through those and tell me if you know what those are.
They are photos that I found within the download of Mr. Anderson's phone.
Were they of note to you for some reason?
They were
Why?
because of prior knowledge of what Sade was wearing that night of the date, along with the timestamps of these photos.
Okay, so you found images that were date and time stamped. Were you able to discern the exact time those photos were taken or no?
No.
Can you explain that?
When I found these photos, we save them, and when it creates the file itself, it'll give us a date and time. And these photos I discovered were recently deleted. Or I shouldn't say deleted, I should say modified is how how it's listed on the actual report.
All right. I have, what's the big stack in front of you? I forget what exhibit number that is.
Exhibit 296.
I have exhibit 296 on the screen in digital format. I'd like you to go to page 40 of the magnet axiom report.
What was the page?
40.
40.
They're numbered at the bottom, correct?
Correct.
Okay.
All right, I'm on page 40.
And on page 40, is there one of the images that is amidst the other stack I handed you?
Yes, this is a photo of exhibit 288.
For the record, I'm going to move 288 through 293 into evidence at this time.
288 through 293.
Yes.
Any objection?
No, Your Honor.
They are received.
What are we looking at?
It appears to be a hand grabbing something.
Okay. It's quite pixelated, so to speak, blurry.
Correct. It's blurry.
All right. Next, I want you to turn to page 43. Actually, let's go to 41. You can just go to 41.
Kevin.
What's the next page?
41 is a photo, or it's exhibit 289.
Is this the photo?
That is.
And why was this of note to you?
Because Sade was wearing light colored pants along with a light color underwear that was recovered.
Are you, and where were those recovered?
They were recovered within her vehicle.
And what do you see right here where I'm circling?
That is the tears from the front of her pants, I believe.
I'm going to show you exhibit 76 on the Elmo. Recognize those?
Yes, I do.
Are these the clothes that caused you to think that photo was of relevance?
It is.
On to the next image
Let me go.
that I have on the screen here. What is this?
Is that 42?
It may not be in the stack, but what are we looking at? What?
That is it was a screenshot or some sort of capture of what not to mix with bleach.
And what was the last modified time of that one?
It would have been around, I believe, 11:28 PM on the 1st. That's April 1st.
I'm sorry, I missed the time.
I believe it's around 11:28 PM of 4/1/24.
The next image, page 43, what are we looking at?
It's another photo of the light colored jeans and the underwear and presumably skin.
And what body part is visible?
It's her buttocks.
The next image,
The next image is another photo. It's kind of pixelated. It looks like a hand grabbing something.
I'm going to go up to page 47. What are we looking at here?
It appears to be, I'll describe it. It's a white, very distinct sweater. I believe it's cable knit sweater is the term for it. And it appears to be somebody laying on their face down on a couch or some sort of item with their breast exposed.
And the next image, is it different than the previous one?
Yes, it's the same. It appears to be the same person, but with this time a hand grabbing the breast.
I'm going to put on the screen exhibit 294, which is a flash drive. Detective, is this one of the images we just looked at?
It is.
Going to image 2, that was number 1, this is 2. Is this one of the images we just looked at?
It is.
And you're saying, I think your testimony was that this appears to be a hand, correct?
Yes,
Are you basing that statement off of what another image depicts?
correct.
But to be clear, these were all different images that you found on the phone?
Yes,
Different file names.
yes.
Next image. What do you see there, detective?
I see it's a zoom up, or the photo that was presented before. It's a cable knit sweater. It's a person laying face down. That person has black hair. They have a darker complexion with their breast exposed. And then there's, it appears to be the red, very distinct couch or item.
Can you get up and point to those things that you were talking about?
So right here is hair, presumably hair. This is the very distinct sweater I was talking about, with the cable knit. Right here is an exposed breast. And then this is red, presumably item of furniture, and that is part of the couch.
Which breast is exposed? Left or right?
I believe the right.
Were you aware at the time you were going through this of what Sade Robinson was last known to be wearing?
I was,
Is it what we're seeing in this picture?
yes.
I'm going to show you exhibit 239. image from Duke's. Do you see that same cable knit sweater?
I do.
How does Sade appear in this photo?
I can't tell based on, from this photo, she's face down on a couch. I don't know if she's alive or dead or sleeping. I can't tell from this photo.
Okay. Next photo. This is different from the last one, correct?
That is correct.
And what are we seeing here?
It's a different variation of the photo from before. Here's the white cable knit sweater, the black hair. It appears to be a white hand, and then her breast, presumably her right breast. And this is a zoom in of that couch, the red maroon couch.
Are you aware of what breast was cut off of Sade Robinson's torso?
I don't recall off the top of my head.
Now what are we looking at?
This is that kind of pixelated photo, but it appears to be a hand grabbing something, and then that's a part of that couch with that, I don't know if it's trim or how you describe it, but that looks like part of the couch.
And this next image?
This next image appears to be her buttocks. There's the very distinct yellow, light colored underwear with the jeans, and then there's the tear from the front of the jeans. And then here's the couch.
The seam of the couch that's slightly visible here,
Correct.
does it look kind of worn out?
Yes,
And is there a color difference between the couch and this other thing right here?
there is.
What's the color difference?
This appears to be more of a red, and then this appears to be more of a darker brown.
And based on the position of the furniture and what you can see of the buttocks, does she appear to be face down?
Yes.
Okay. I'm going to pull on the screen Exhibit 318. You see comparable furniture in this image?
I do.
Point that out, please.
Here's that couch I was describing. It's a red in color. Here's that trim or seam I was describing. And this is the ottoman that was within the apartment.
On the couch, there is somewhat of like a blue pillow or something, correct?
Correct.
Point that out, please.
I believe it's right here.
Going back to the images. Do you see that in this image?
It's right here.
Move 294 in, which is the flash drive that has the images that are contained within the paper exhibits, I want to say 289 through 293.
Any objection?
No.
Received.
You can have a seat. Did you attempt to ascertain the times in which any of those photos were taken?
I can only go off of what the program showed me, and it only said it was a modified date.
What does that mean to you?
That image was modified in some way or form.
And at what time and on what date were those images modified in some way? You can take your time to page through them if you need to.
Thank you. Okay. It appears that most of these images were modified. It would have been 4/2 of 24. With the UTC conversion, it would have been 12:05 a.m.
going to go to the last page of the Axiom report. Oh, sorry, I unplugged it. While I'm pulling this up, was there an Uber ride that was noted in the report?
I did not notify I was made aware of an Uber ride, but I did not document it.
Okay. Let's go to the last page of the magnet report. Is it indicated on that or no?
Let me look. It was page 92. I tagged the Twisted Fisherman Crab Shack.
Is this an Uber ride?
Yes.
Okay.
Sorry.
What time was that Uber ride taken?
It would have been like 3 p.m. on the 2nd would have been the email. I think it's the email.
Okay, you got an email about an Uber ride. The email came in at what time?
It would have been 3 on the 2nd.
An incoming email?
Yeah.
Okay, from Uber.
It says that it's from Uber Cab and the source, so, yes.
And it's denoting the Uber ride to the Twisted Fisherman?
Believe so. Yes.
All right, and then Detective, I have exhibit, it's already been entered, it's 295 on this, it should come up on the screen shortly. Was this another image you found on that phone?
It is.
What do you see here?
It appears to be a beach. I know from being at that Warnemont Park that it appears to be Warnemont Park. There's 2 dogs playing in the sand or running in the sand, and there's water to the right.
Was that image modified? Do you know?
I don't recall.
Okay. And you tagged this photo specifically why?
Does it appear to be Warnemont, where we discovered Sade's leg?
I'm going to put on the screen exhibit 2 next to it, which is from the scene photo of the leg recovery. Does it appear, can you see the leg right here that I'm pointing to?
Yes.
Does it appear to you that those photos were actually taken almost in the same location?
Approximately, yes.
Nothing else.
Cross.
Good morning, Detective.
Good morning.
So I just want to first start with, did you actually examine the physical phone?
No.
Okay, so what you got was kind of what was the download from the Cellbrite, right?
Yes.
And so I want to start with talking about this conversation between Mr. Anderson's phone and Sade's phone. So those messages were found in Max's phone, right? And you located those to the download, right?
Correct.
And it was displayed as like a text thread between 2 different people, right? Sade's phone and Mr. Anderson's phone, right?
Yes.
And that thread wasn't deleted, right?
No.
And these tools that you're talking about, Cellbrite, Magnet Axiom, AXIOM, right? That's the program that was used.
Correct.
Those are programs that are used by law enforcement, right?
Yes.
And they're used to recover deleted messages is something that they can recover, right?
Yes.
Deleted emails,
Yes.
and they can recover browser history as well, right?
Correct.
And I just want to make sure I understand this. Celebrate is used for phones, and Magnet Axiom can be used for phone or computer, right?
I believe both can be used for both.
Okay. And so those text messages, you said the conversation begins on March 30th, right?
I believe so.
And that's a couple days, that's like about 3 days before this leg is ultimately found, right?
Yes.
The conversation starts at 1:33 a.m. Max texts Sade's number, his name, right?
Correct.
And then she sends her name back
Yep.
almost immediately, right?
Correct.
And that's pretty normal and common when people are exchanging numbers. If someone gives you their number, you text them your name, so then they can put you in their contact list, right?
Yes.
And when you were reviewing the phone, was Sade's contact added to Max's phone?
I believe so.
Okay, it wasn't a deleted number, right?
No.
And the phone number wasn't blocked, right?
No.
And so after they text each other their names, Sade texts Max's phone and says that she forgot her comb, right?
Correct.
And she asked him if she could bring it back next time he sees her, right?
Yep.
And he responds, of course, I'll bring it on Sunday, right? He texts that,
Yep.
suggesting that the two had plans to see each other on Sunday, right?
Correct.
And she responds, thank you.
Yep.
And the texts, the bubbles that we saw, do those show emojis or not?
The ones that I made the report with, I don't recall if it did or did not.
Okay, does the program typically pick up like when emojis are sent, or is that not something the program can?
It depends on the phone, the carrier, the phone, and what level. I don't know how to explain that.
Okay. And then they're continuing to text from March 30th, and then they're continuing to text on March 31st as well.
Yes.
Max is texting, asking her how her night's going,
Correct?
and she's responding.
Yes.
She says she might even stop there. She texts that, right?
Yes.
And Max responds, I'm here.
Correct.
Suggesting that she knows where Max is, and she might plan to see him, right?
Yes.
And then they continue to text, and they talk about meeting for a date, right?
Yep.
And she says she's working, and Max suggests that maybe they do it a different night, right?
I believe so.
And then Sade chooses today. She says, I can meet today.
Yes.
And ultimately, they agree on a place.
Yes.
I think it was first Broad House, and then ultimately they decided on the Twisted Fisherman.
Yes.
And in those texts, Max says, he mentions his W-2, right?
Yes.
Which would, maybe assume that maybe he worked there. That's what W-2s are typically for, work-related stuff.
Yes.
So a place he worked at, they had planned to meet.
Yes.
Place that he's probably known at, right?
Yes.
And so these texts that we reviewed, these are just two texts between two people getting to know each other and agreeing on a date, right?
Objection calls for the witness to speculate on their mindset.
Sustained. Next question.
Those text messages, there's no threats in those text messages, right?
Correct.
There's nothing aggressive, there's no aggressive language used?
I don't know how you define aggressive language, but I would say no.
Okay. And so in those text conversations, Sade never sends and never mentions her address, correct?
Yes.
So her address is never sent to Max in any of those texts, right?
No.
Or the name of her apartment,
Or one more time?
or the name of her apartment,
No.
or even the general area of the city that she lives, right?
Correct?
And then we saw there was a gap between the last message where I believe she says, Max says, I'm inside, right? And then there's a gap. And then the final text is morning, how's work going, right?
Yes.
So after the date that, they presumably went on, he sends a message the next morning, right?
Yes?
That's not unusual to text someone the next morning after a date, right?
Yes?
So you determined that you believe that there were some photos that you believe were Sade found on the phone, correct?
Yep,
And you said that those were photos, right?
correct.
Are you able to determine whether they're photos or a video?
I believe there were photos.
Okay. And do you know what times the camera was utilized, or will you not be able to tell that with the tools you had?
I won't be able to testify on that. I don't know.
Okay, yeah, that's fine. But those photos, a lot of those were pretty grainy. You could see them on the screen, right?
Correct.
And did you have to utilize any tools to enhance them at all?
There was one photo that was sent, I believe, to the crime lab to be enhanced.
Okay, so some of these photos, that's not the actual form that they were found on the phone. They were enhanced through a crime lab, right?
Objection, that's a mischaracterization of the testimony.
I think that does misstate the testimony. You want to re-ask your question?
Okay, but the photos, they were sent to the crime lab to be enhanced, right?
Certain ones, yes.
Okay. And you said that the photos were modified. You can't testify that they were deleted?
According to the information below the photo when I created this report, all it says is modified, under
Okay.
the modified category.
But if they were deleted, your report, and you can't testify why those photos were deleted, right?
I cannot testify why they were deleted, no.
And because people delete photos for a variety of reasons, right?
Correct?
Like if they're poor quality,
Possibly.
if it's to save storage space. I mean, people delete photos for lots of different reasons, right?
Sure.
Or like an explicit photo. You wouldn't want like an explicit photo on your phone to be leaked, right?
I don't know.
And so those photos that we saw, those weren't the only photos that were deleted, right?
Modified, you mean?
Or yeah, modified, I'm sorry.
That's correct.
There was some screenshot that says things not to mix with bleach. We saw that, right?
Yes.
And was that an actual photo taken from the phone? Was it like taken because it looks like it's almost like a pamphlet or like an instruction card?
I'm not sure if it was downloaded or screenshot. I don't recall.
Okay. And did you pull, or is your data able to tell you whether photos have ever been deleted in the past, prior to, was this April 2nd?
Sorry, one more time?
So did you analyze data from, let's say, February of 2024, if there was any activity on the phone where photos were modified?
I was provided a copy of the phone download that we had, and I was able to review all of that.
Okay, and do you know what the date range of that was?
I do not.
As part of your investigation, did you review anything about the search history on any of the phones or anything?
I reviewed the phone. I don't recall the search history.
And I just want to make sure it's clear, there were other modified photos. The ones that the state showed on the screen were not the only ones, right?
Correct.
I don't have anything else. Thank you.
Steve?
One might also delete photos from their phone to cover up for a crime, correct?
Objection, speculation.
He
He
asked those questions.
All the possibilities. You can answer it if you're able.
Yes.
And
There were other modified photos of Sade, just not from the house, right?
I believe so.
Okay. Other photos from, that were on the phone that appeared to be from her social media?
Yes.
Okay. How many?
I don't recall off the top of my head.
And let's look at what I have on the screen here. Was this another image you had tagged?
It is.
What is it?
It is the USFIR, and it states human leg found at Warnemont Park. Sheriff's Office says.
What's USFIR?
It's I'm not exactly sure how to explain it. It's a Facebook or Instagram where they'll post things about law enforcement activity, I believe.
And when was this image modified? If you can, I'll zoom in.
Approximately 10 o'clock a.m. on April 4th.
Now, when we were talking about the modified times, all of these photos also came, the ones that were modified had this created and last access date and time, right? Not all of them, but a lot of them, including the ones that we had gone over earlier.
Yes.
And what is the date and time denoted there?
On this, it's 1/1 of 1970 at 12 o'clock a.m.
Did you figure out what that's all about?
I don't know how or what that actually, I don't know. I can't testify to that.
Okay. But clearly this image right here wasn't taken back in 1970, right?
Correct.
Okay. And just to be very clear, because I think there might have been some confusion, the photos as we have seen them on the screen today, those photos were as is as you found them on the phone, correct?
Yes.
And all of this information we've covered today came off of the defendant's phone,
Yes.
nothing else.
Defense?
Yes, just briefly here. We look down here on the source, and it says Instagram. We see that, right?
Yes, it says Instagram.
So is that saying that, is that where this image was viewed on, was Instagram?
Possibly. It says Instagram with the .com on it. So it might have been viewed from Instagram, correct?
Well, you're an expert in analysis or not?
I am not.
Okay, but so you're not able to testify where this photo was viewed from, if it was viewed on a website or if it was viewed on Instagram?
Correct.
And social media platforms are commonly have news stories on them, right?
Yes.
A lot of young people of the younger generation, even their 30s, get their news from Instagram because there's hundreds of, maybe thousands of different news websites, right?
Correct.
And someone doesn't even need to follow that specific news, that news team or whatever, to get news stories on their feed, because sometimes they're suggested things on Instagram, right?
Yes.
Is there anything in this record for you to be able to conclude that he ever even clicked on that link?
I don't know. I'm not
Okay.
an expert on it. I can't say it.
Okay, and I don't have anything else.
State?
No, nothing.
Thank you. Anyone need a break, or are you good? Need a break? Okay, we'll take our break right now. We'll come back shortly and continue. Can you give this to my clerk, please? Thank you. Okay, we had a sidebar at 10:04 a.m. During the course of that sidebar, I had called it. I had received notice that the camera angle was catching the notes of the defense team, and I wanted to alert them to that so that if they were concerned, they put their computer screens down or take appropriate action. Anything, State, you'd like to add to that?
No.
Defense? Anything to address on the record now, State?
Just one thing, there was a request that I understand was brought before the court by the state earlier to ensure that the media not show or identify the previous civilian witness, and I just wanted to make sure that was understood.
So I received a number of emails pertaining to that. What was indicated was that witness's name was not on the list of names originally submitted, that I was notified while the witness was testifying that there had been a request made by the victim witness personnel to the media to preclude the identification or the live stream of the witness. My response was, it was not part of my original order, and it's an open court, and that I hadn't made a previous ruling and I had not previously instructed the media to not do so because I was not put on advance notice. And I indicated based on that, I think that they have the right to do as they deemed appropriate. Knowing that the victim witness coordinator had made such a request while, I don't know if it was made during her testimony or before she testified. She's nodding her head to before she testified. But I was aware of that, and that was my response because it was not part of the prior rulings I had made.
Understood. Just,
Okay.
thank you.
Yeah. Anything else? No. Okay. Then we'll take a brief break and come back and continue.
State of Wisconsin versus Maxwell Anderson, case 24, CF1692, same appearances.
There was an unusual email that was sent to Defense Counsel, the state, and me. Mine went into spam, so I didn't see it, but Attorney Cotton showed it to the state as well as to me. Is there any action, defense, you're asking to be taken?
No.
State, any action?
No.
Okay. I'll continue with my normal admonitions at breaks and in the end of the day. State, are you prepared to call your next witness then?
Yes.
Anything further to address before we bring the jury in?
No.
Defense? Okay, we're ready. Please call.
Jason Ruff.
Do you solemnly swear that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
If you could please be seated, state and spell your name for the record.
My name is Jason Ruff. That is Jason. Last name Ruff.
How are you employed?
I work for the Wisconsin Department of Justice at the Division of Criminal Investigation.
What is your job title?
I'm a senior digital forensic investigator.
What does a digital forensic investigator do?
So what we do is when sworn officers, special agents for the Division of Criminal Investigation sees electronics, they are brought to our office and we conduct examinations of pretty much all the ones and zeros that are flowing through all of the systems. So like phones, servers, computers, anything like that, we recover that data and kind of see the types of activity that were on it in a scientific manner.
Do you have any special kind of training that qualifies you to examine forensic data from electronic devices?
I do. I have a master's in cybersecurity with a focus in computer forensics. I have another master's from John Jay College in criminology. I have gone to a large number of trainings through the National Computer Forensic Institute with the Secret Service. I have several trainings with the National White Collar Crime Institute, and just kind of a litany of different certifications, specifically with the IASIS, which I can't specifically remember off the top of my head what IASIS stands for, but it's the International Computer Investigators something, so.
And so what is it that you predominantly spend your time doing?
So primarily I am behind a screen looking at data that has been acquired from just different devices that have been seized related to criminal investigations.
Were you asked to do forensic examinations related to 2 devices recovered during the course of the investigation into this case?
I was.
And was one of those items Maxwell Anderson's Samsung Galaxy S22 phone?
It was.
Can you tell me, do you examine the phone itself or are you examining something else?
So in this case, because I came on a little bit later, I examined what's called the extraction of the device, or the forensic image of the device, which is acquired by another examiner and then was given to me to look at.
A forensic image is essentially what?
So it is, there's different versions of it. Forensic image would be a bit for bit copy of the actual data that's on the device. Now, what makes this somewhat more difficult with cell phones is because cell phones have all those applications that we have on there, which has lots of encrypted proprietary data that most of those companies wouldn't necessarily want myself or anybody else knowing how they fully create those things. So what we get is what's called a full file system extraction, and a full file system extraction is pretty much all the data that you can possibly get from a phone within the file structure of the actual device itself.
And were you also asked to examine the forensic image or extraction from a different item?
Yes, I was.
What was the second item?
So the second item was an actual forensic image of a computer hard drive.
Did you prepare a report related to what you found after conducting those examinations?
I did.
I'm going to show you Exhibit 495.
Thanks.
Is that your report?
This is.
Move 495 in.
Any objection?
No.
Received.
Now, I want to start going through Exhibit 495 first by, let's just go through it front to back here, okay?
Sure.
So what do we have? What did you do?
So the first part is me describing the tools that I used, which I can list off. The tools were because like in anything you need tools to conduct your examinations. I used X-Ways Forensics, Magnet Axiom, Celebrate, ALEAP, Notepad++, DB Browser for SQLite.
So much of this is narrative that you typed yourself, but a lot of what we're going to see is stuff you put into the report directly off of the Samsung device, correct?
Correct.
And these things I've highlighted here, I think they're what you just listed off, right?
Yes.
All of those are just programs you use?
Yeah, so the different forensic tools for just different things that need to be done for either recovering certain data or analyzing certain data.
All right, and then you had found a text conversation between the phone. Well, what was the phone number for this phone, by the way?
So the phone number for this phone
I have it highlighted on
yeah, it would have been 262-416-4874.
And you looked at the conversation between this phone and Sade Robinson's phone?
Yes.
Did you ascertain whether any phone calls had ever been made between Maxwell Anderson's phone and Sade Robinson's phone?
I could not find any phone calls.
So from what you looked at, it appeared they only communicated through these text messages.
He's leading the witness.
I'll rephrase it. Did you find any other communications beyond text messages
I did not.
between those two phones? Sorry.
I did not, no.
All right, and as we go ahead here, this is the phone conversation.
Yes.
The last text message is sent at what time?
So the very last text message between those two phone numbers is sent at 10:36 and 16 seconds in the morning AM.
So in these timestamps, these are going to be in real time?
Well, yeah, they're going to be in Central Daylight Standard Time.
Okay, thank you. Did you go on to see whether the device interacted with Sade Robinson's Instagram account?
So I wouldn't be able to say whether or not it was the actual Instagram account, but it interacted with something on Instagram that cached images that appeared to be of Sade.
Tell us what a cached image is.
So a cached image, the best way that I was kind of taught it is when you think of surfing the web, what you're actually doing is actually downloading the web to your device. And part of the reason that happens is just for the purposes of allowing your device to potentially reload things that you frequent. Just because something's cached doesn't necessarily mean it's a frequently viewed thing. However, when you, for example, scroll through Instagram, as you're scrolling through Instagram, it creates thumbnail or representative images on your phone within that application, so that if you scroll past those again, it will load faster. And those are cache images.
So your phone's essentially remembering the images it's seeing.
Correct.
I'm going to go down. I think this is going to be going on to page 5 here. Were there cached images of Sade?
Yes, correct.
And to clarify, there can be cached images that were taken by the device itself, right?
Yes, yeah.
So like if you took a photo with your phone would also cache that?
Correct, for various different reasons.
All right. So it's not, my point is it's not just web surfing or social media browsing.
No,
Your phone is doing that throughout whatever apps.
correct.
Okay. What do we have here on page 5 on the screen? I have it up next to you.
So there were a total of 10 images that I found from this time period that were cached. These are just 2 representative images from the application Instagram of someone that appears to be Sade.
And when you say this time period, what are you talking about?
So would it be the timestamps that the cache images were, which I believe was, here I have to look.
What time stamps were images of Sade cached?
7:33 p.m.
On what date?
This would be the 1st of April. My apologies.
On the screen now, are those 2 of those images?
Correct.
All right, let's move ahead to 10:07 p.m. What starts happening on the phone at 10 o'clock?
So from 10:07, 10:09, 10:12, 10:22, and 10:57 p.m. on the 1st, I start seeing usage of the camera. So everything on your phone is a different application. So basically, you see the application that's built into the Samsung pull up the camera application.
How is it that you're able to see all this again?
Because with any interaction with your phone, if you kind of think of like either Domino's or Rube Goldberg or something like that, just because, for example, you are just clicking on a photo, for example, and it pulls up, there are a litany of different things that are happening behind the scenes. So, and I think it's further in the report, you'll see that things are being stopped and started so that different system resources can get access to those applications.
So you were able to tell that in the 10 o'clock hour, it looks like on 5 occasions, the camera on the phone was activated?
Correct.
Would that require user interaction with the phone, human interaction?
Yeah, it would.
What about after that?
After that, there is somewhat of a lull in usage, and then until the next morning, I would say.
All right. What did you notice occurring on the phone at around 12:05 a.m.?
So at 12:05 a.m., a user unlocks the phone, and the phone's display turns on and goes to the last activity that would have been happening on the phone, which in this case was usage of the gallery. So like if you scroll into your phone, your gallery, just your images.
At 12:05?
Correct.
Is that what I have on the screen here, or am I in the wrong spot?
Yes.
Okay. And specifically 12:05 and 37 seconds a.m.?
Correct.
And what gallery specifically are you talking about?
So this would just be the regular Samsung gallery. So if you click in it to look at all the photos you've taken.
Photo gallery.
Yes, correct.
Okay. And then what's happening after 12:05?
So after that, and this is kind of where I get into that whole dominoes or Rube Goldberg as you press on things, the user transitions to the camera application, which pauses the actual gallery application because they're technically two different applications, even though they're kind of morphed together, which then subsequently stops usage of the gallery itself.
And how often does that occur starting at 12:05?
I would have to look specifically, but I believe 3 occasions.
All right, well, let's just keep going. So at 12:05 and 38 seconds, what happens?
So at 12:05 and 38 seconds, the camera is launched, which is then launched with a third application, the launcher, which launches and pauses things, which then causes the phone itself to stop the gallery application.
What happens next?
Then after the gallery application stops, several seconds later, the camera pauses because it goes back to, or not seconds, milliseconds later, the camera goes back, or the camera pauses and goes back to the gallery application.
And does that interaction then stop?
Yes, and then a second later, about, the camera application stops.
After that,
the gallery application is once again paused and the camera is launched again several seconds after that.
and by 12:05:42, what's going on?
12:05:42, oh, I think I skipped ahead. 12:05:42, I see that there is some interaction with a cache image. I can't determine what that interaction exactly is.
Okay.
So there's a modified date to that. So there's some sort of interaction with the photo.
Then what happens next?
Then the gallery application is paused.
And what continues to happen until 12:08?
So until 12:08, this kind of sequence of events happens until there is, like, it goes from camera back to gallery, and then there is a period in between there when it the pattern of usage appears that the bunch of images are deleted.
Tell us about that. What time does that happen?
So the deletion period begins at approximately 12:05 and 53 seconds. It starts, there's an interaction with about 32 cache images.
Is that what I'm highlighting here on the screen?
Correct.
Okay.
Now, the interaction with those images, it could have been more or less of those images. Those are just the images that the cache was left over from after that period. Shortly after that interaction, there is a, the delete services of the phone begin. So it starts deleting, and then a millisecond or so after they hit delete, there's a notification interruption. And that notification is simply the phone saying, are you sure you want to delete these images?
Okay, so I just want to break that down a little bit because that was a lot, and a lot of lingo too. At 12:05 and 53 seconds, there are 32 images that you identified as having a modified timestamp. Is that correct?
Correct.
Do you know what modified means is happening to those images?
Yes, so there's interaction with those images.
Human interaction?
Yes, human interaction.
This is not the device doing
this is
itself
not
on
the
its own?
device. Yeah.
Okay. And are you able to tell what happens with the human interaction to those images?
Based on the time frame and when the phone itself actually has in the actual timeline itself, the next actions that happen within that system is deletion.
Of those images that were deleted?
It is highly likely that it was of those images.
Okay. And included in those images, were there images purported to be of Sade Robinson?
Correct.
And I'm going to scroll down. Are these those images?
Yes.
This last one was modified, correct?
Correct, yeah.
Purposes of presentation?
Yes.
All right. Are you aware, for that particular Samsung phone, what a person practically would have to do to delete those photos?
So yes, I did actually a lot of tests with this with an actual Samsung S22, so I could verify what I'm talking about. They would have to go into their gallery, essentially select all of the images, and then hit delete, and then that notification pops up and says, are you sure, essentially, are you sure that you want to delete these images? You hit yes, and then they're gone.
And is that what happened here?
Yes.
What happens next? I think I have up here, is this the delete service?
Yeah, so like I said, phones are just a bunch of applications. So there's an application for deleting those applications within the actual gallery application occurs. It stops shortly, several seconds later. And then it eventually is started again, several seconds after that.
What started again?
The deletion is started shortly after it stops again.
Were there more images deleted?
It is more than likely that more images or videos were deleted at that time.
Okay. Were you able to see which images?
I was not.
But in the prior instance, you could see the 32.
Yes, correct.
What happens after 12:06?
After 12:06, you mean 12:06 and 35 seconds?
Sure, why don't you just keep taking us through it?
12:06 and 35 seconds, there's that notification interruption. Then shortly after that notification, the delete service is stopped again. And then again, several seconds later, the delete service is started again. Notification happens at 12:06, several milliseconds after that. And then the service is stopped. And then the gallery, which is where the delete services are happening in, is then paused and the camera is launched again.
What time is that at?
So the camera is launched at 12:06 and 56 seconds.
Does that necessarily mean the camera's being used to take photos?
Not necessarily. I mean, could have accidentally hit the camera application.
After that camera is launched, what happens?
After that, almost simultaneously, obviously the gallery is paused, and then shortly after that, the camera is paused and a user goes into the phone settings.
Okay, what happens once the user goes into the phone settings?
So the user is in the settings for about 20 seconds or so, maybe a little bit longer.
Beginning at what time?
Beginning at 12:07. Well, beginning at 12:07, they're in the actual settings application. The first configuration change within the settings is at 12:07 and 23 seconds. And then again at 12:07 and 25 seconds.
And what's happening there?
So essentially, a user is changing some form of network settings. Unfortunately, because of how some of this stuff is recorded, I can't tell what exactly those settings are specifically with network. Certain network settings will only tell you what the last state of the settings were. So if you turn on or switch Wi-Fi or any of those types of things, it's gonna record the last state that it's in from the time that it was downloaded.
By network, you're referring to like the cellular network that's servicing the phone?
Yeah, either cellular network, Wi-Fi, any of those things, Bluetooth.
What happens shortly after 12:07 and 25 seconds?
So shortly after that, there is a notification from the operating system that pops up. I don't know again what that notification was, but
A phone notification?
yeah,
Not something the user's doing?
no, not something the user's doing.
And then what time is that at?
That is at 12:08 and 38 seconds.
All right, now this is beginning after 12:08 and 38 seconds. What are you seeing?
I do not see any user interaction or human user interaction.
Human user interaction. When is the last time that you see human user interaction with that Samsung phone?
So the last time that I can determine that there is any human user interaction for sure is at 12:07 and 25 seconds. There's possible human interaction for that 12:08 time period that caused that notification, but it's also likely possible that there was some other system thing that popped up because of it.
Okay, so let's just assume for the sake of argument, it's the latter one, the 12:08 one.
Correct.
Do you see any human user interaction on the phone for the rest of that night for hours?
No,
That's the last time?
that is the last time.
Until when?
Until the next, well, not the next morning, several hours later at 8:59 a.m.
On April 2nd?
on April 2nd.
So from 12:08 a.m. to 8:59 a.m., are you saying that there was no human user manipulation of the phone?
Yes, there was absolutely no human user interaction.
What happens, and I have on the screen here, is this is you documenting that?
Correct.
Okay. So in sum, can you just, and I think it's up on the screen here, but just summarize briefly what exactly we're seeing occur between 12:05 and 12:08 on the phone?
So a user is going between the applications and the camera back and forth several times. Then they begin deleting things, and then there are some form of configuration changes in the settings, and the phone is not interacted with
After 12:08?
after 12:08.
And in there, we know that the camera was used.
Correct.
Okay, and so you know that there was camera usage from that phone after 9:20 p.m.?
Yes.
What happens after that? I know you said there's no user interaction, but as you go
Yes.
forward, you saw some things?
Yes, so at 12:17, so approximately 10 minutes or so, maybe a little bit less than that, later, the phone registers itself as being inactive, so the screen goes into an inactive mode, essentially like a somewhat, I guess, you could parallel it to like it goes into sleep mode. The screen still stays on, but the phone is in a sleep mode, which then pauses the last application that was open, which was the settings.
So that's not a user doing anything?
No, that's the exact opposite.
Okay. After that,
So then settings are stopped almost simultaneously from that period of time.
are you able to conclude that between 12:45 a.m. on April 2nd and 8:43 a.m. on April 2nd, there's no user interaction with that phone?
I can 100% conclude that.
There's some notifications that come in, though, overnight, right?
Correct.
Tell us about that.
So when you have social media, there's different types of timestamps and everything when it comes to digital media. There are the timestamps that are recorded from when you are interacting with your devices that are changing those timestamps. And then, for example, when you're talking about social media, email, really anything network related, there are also timestamps from, say, the other person who maybe posted it or sent you that email. Those timestamps are going to be from likely when the actual email or post was created, and that is registered to whatever server is hosting whatever application that is. That created timestamp doesn't mean that somebody's actually interacting with that on that specific device. It's just the time at which that was registered to outside servers.
There were some of those overnight after 12:08?
Correct.
Okay. I have one on the screen here, 12:09, or excuse me, 12:49. There was some kind of social media notification.
Correct.
And then 12:59.
Correct.
Okay. What starts happening at 1:21 a.m.?
So at 1:21 a.m., the phone screen officially turns off. And then shortly after this, there is a notification that comes in, and it's about 2 or 3 minutes after that, there's what's called edge lighting, which I don't know if any of you have Samsungs, but essentially the idea is that when you get a notification, the outside edge of the phone lights up to let you know there's a notification, even though the screen is off. And then 4 seconds after that, it lights up again just to remind you that the notification is there.
All right. Then what happens?
And then the phone begins to power off.
Describe what happens to the phone.
So the phone had a low battery state and the phone essentially dies. So as a phone is dying, essentially the phone starts moving different things and energy towards more important aspects of what the phone actually is meant to use for. So for example, if you're out in the woods and your phone is dying, the last thing that's going to probably turn itself off before dying is going to be your ability to call for help. So certain applications, so the screen turning it off, it was going into a low state, and then the phone kind of starts checking itself to make sure that is there really not power, or is there something else going on with this phone? Doesn't mean it's not going to turn itself off, but that's essentially what happens. So this artifact, essentially I don't know if he's got that up. Oh, so the Samsung Wellbeing gives you the ability to kind of look at your own phone usage. So it starts recording that the phone is powering off, and then there's an internal application that usually doesn't necessarily parse out with a lot of forensic tools called the ERR.P, which I guess that's the name is, I guess, irrelevant, but what it is it records different powering events on the phone. It records, for example, when the phone is factory reset or first set up. It records when a human user turns off the phone. It records when there is a shutdown and power up related to a system. So like when you're updating the operating system of your phone, it frequently has to turn itself off, and then it registers when the phone dies. In this case, it registered that the phone died due to lack of power.
And at what time did the phone die due to having no power?
At approximately 1:35 and 57 seconds.
Is that what I have highlighted here?
Correct.
Okay. And below that, it would be the artifact that you're talking about?
Correct.
That is not the same as someone physically turning the phone off, right?
No. So if the phone is physically turned off, this artifact registers it as an unrequested because it's essentially monitoring the system itself. So if the system requests that something be turned off, then it'll be recording why it was turned off. If a human user interacts with it, it is listed as unrequested.
And were you able to identify the next time that the phone was connected to a power source or had power?
Yes, so the phone at about 8:59 in the morning.
8:59 a.m. on April 2nd?
Correct.
And what did you see?
So the phone registers that there is no power, and it goes into a low power mode, likely due to a phone being plugged into a charger.
And then how about when the phone turns on?
The phone officially turns on at around 9:20 in the morning.
All right, and throughout the night, there were other notifications, right? But the phone was off?
Correct.
And when you're seeing those notifications in the phone, are you seeing obviously the time they would have been received or gotten to the phone, or what?
No, we are seeing the time that those were created.
All right, so I have one up here. For example, at 2:09:32, the phone would have been dead, right?
Correct.
But nevertheless, you're seeing this Facebook notification that I have highlighted here.
Yes, so that would be the created time of that post on the news feed.
The created time on Facebook and it has nothing to do with the phone.
No, that's relevant to Facebook.
All right. Throughout the night, there was an email from Uber, correct?
Correct.
What time was that email sent to?
So the email was sent and recorded on the email server, so Gmail in this case, at 3:51 and 17 seconds
And from Uber?
from Uber.
And where was the Uber ride?
So the Uber ride was from the previous night, and I will have to scroll past because I did the entire thing. The Uber ride was to 1200 West Canal Street.
Is that the Twisted Fisherman?
Correct.
So this email was just a bill, the receipt for the Uber ride,
Correct.
sent at what time?
At, well, I'd have to go back. At 3:51 and 17 seconds.
Were there images? There were a number of other social media notifications that you could see, correct?
Yeah, throughout the early morning, there's a bunch of Facebook notifications or Facebook news feed.
But again, the phone's off at that time? Okay. Did you notice what time there appeared to be user interaction with the phone again?
At 8:59 in the morning.
And sometime prior to that, obviously it gets connected to the power source. What time does it turn back on?
It turns back on at approximately 9:20 in the morning.
So the first human interaction you're discussing, that's the,
So, yeah, so between 9:19 and 9:20. So there's settings on your phone that when your phone dies or you turn it off, they're literally called persistent settings. These settings are so that all the settings you have on your phone, you don't have to go through your phone and reconfigure your phone. So these settings are some of the first ones to activate themselves upon your phone reactivating, and that reset of these settings occurs at approximately 9:19 and 54 seconds.
so the phone's back on by 9:20 a.m.
Correct.
after having been off since 1:35?
Correct.
Okay. Throughout the date of April 2nd, did you notice there were other interactions between this phone and images of Sade Robinson?
I did.
Tell us about that.
So on the 2nd, at 4:10 p.m. and 4:24 p.m., there were several cached images from from Instagram of what appears to be Sade. And then, yeah.
How about April 3rd?
Again, on April 3rd, are 2 photos cached of looking at the Instagram images or interaction with.
All right, let's move on to the computer tower. What did you notice on the computer tower beginning in that similar time frame shortly after midnight?
So shortly after midnight, there's a user on Netflix, and at approximately 12:07 and 38 seconds, they search within Netflix Love Death, which brings them to the Netflix show Love, Death, and Robots.
Whose computer is this again?
I was told me to be Maxwell Anderson.
Okay. So the computer goes to Netflix at 12:07 and puts on a show, Love, Death, and Robots?
Correct.
And then tell us what you're able to see about what happens with Netflix and what you were able to determine is specific user interaction and when that stops.
Sure. So from that period of time, the first show is queued up, and that is an episode called 3 Robots Exit Strategy. After this, the user several seconds later transitions to another episode called Bad Traveling. The show begins to play several seconds after that.
What time is this at?
That is at 12:07 and 50 seconds.
Okay, then what?
Then shortly after that show ends, the next episode begins to autoplay. this would be the episode, The Very Pulse of the Machine.
At what time?
That is at 12:08 12:08 and 16 seconds.
Okay. That was not user interaction, that was Netflix auto playing?
Yes.
Okay, then what?
Then around a dozen minutes after that episode begins, its credits transfer to the Night of the Mini Dead, which plays. It's just under 7 minutes. Again, I tested using the same browser and everything to check the properties of how Netflix worked at that time. And approximately when there is the time when Netflix starts to autoplay the next episode is when that episode starts to transition and beginning, which would be this Night of the Mini Dead.
Okay, and what time is that happening at?
And that is happening at 12:23 in the morning. And
Is that what I have on the screen here highlighted?
yes, that is correct.
So when's before 12:23, when is the previous last human interaction with Netflix?
Before 12:23 would be around that 12:07.
So from 12:07 to 12:23, Netflix is just playing on the computer, and then at 12:23, is there human interaction at 12:23 or no?
At 12:23, shortly thereafter, well, no, not at 12:23. Shortly after that, there is user interaction about 5 minutes after that.
At what time?
At 12:28 and 11 minutes.
And he puts on an episode of what?
An episode of Three Body Problem, which is a suggested show under Love, Death, and Robots.
And does the episode play?
So it sits on there, but the user transitions to that and then begins to play the first episode.
What time?
So it begins to play at 12:33.
So and then how long is that episode?
That episode's about an hour, I believe.
Is there any user interaction with the Netflix throughout the night after that time?
No,
With the computer tower at all?
no.
So just to recap for the computer, there's user interaction with Netflix at 12:07 a.m.
Correct.
That stops. Then shortly after 12:23, there's an additional user interaction at 12:28?
Correct.
And then after 12:28, is there any other user interaction?
No.
Any user interaction with the computer tower whatsoever between 12:45 a.m. and 8:43 a.m.?
No.
There's stuff going on in the background of the computer, though?
Correct.
Can you summarize that?
Yes. So, there's a lot of system activity with a computer that's tied to the internet. So just to name a few, there are what appear to be logins, but these logins are system only. So when you aren't using your computer, the computer is doing maintenance of itself. So it's logging in and out. There's different security IDs. So one of the ones that I have down here listed is it's a Windows event log 4625. And it's a type 5 service, which is again, operating system only, not human interaction. What ties further is the Wi-Fi lease is up. So essentially at about, what time was that? About 2:35 a.m. in the morning, the internal IP address for the computer itself's Wi-Fi lease expires. So what this essentially means is there's different types of networks. You have your internal network, then you have your external network, internet, and all of that stuff. In the internal network, in all networks, there's a finite amount of IP addresses. So what your router does is it cycles through these things. And your router has basically this dynamic host within inside of it that reassigns things IP addresses. And the reason you need an IP address is it's essentially, if you think of your house or your apartment, it's that number on there so that the traffic knows where to go. So at about 12 or 2:35 in the morning, the lease expires. It appears that this the router for this was only set up to have about an hour period, which is fairly short, which causes interruptions with like streaming and things like that, which would be the reason why Netflix stops at that exact time, because it can't reach out to Netflix because it doesn't have an IP address for a millisecond or two to pull the next episode.
So when the episode is started at 12:28 a.m., well, first of all, are you aware if Netflix will just continue to play the next episode?
Yeah, Netflix plays 3 episodes on average, unless you change the settings, but it will auto play 3 episodes and then do the whole "Are you still there?" kind of thing.
Is that what was happening here?
Correct.
Okay. No further user interaction with the computer after 12:28.
Correct.
Just a couple clarifications. I actually want to touch on one thing. When we looked at those, when we looked at some of those cached images from the phone, a lot of those have it's like a created date that says January 1st, 1970.
Correct.
Can you tell the jury what that's about?
So in computing, computers obviously don't understand time, so they need a time frame from which to start. So there's different things that in computing is called epochs. So they pick a specific time in history that creates essentially a calculation from how far from that date we are currently now. So when there are no actual dates, it will revert back to that epoch time. So, and off the top of my head, I couldn't tell you which type of epoch it is, but I believe it's potentially the Unix epoch time of 1/1/1970, which essentially means there's no date.
It's just kind of a default.
It's a default, correct.
I have no other questions.
I think we'd like to start after lunch if we could.
I think that's fair. It's 10 minutes to noon, so we will take a break at this point. Remember the admonitions. Remember, no communication between each other about this case, no discussion with family or friends, no posting, no emailing, no texting about anything to do with this trial. Wear your juror badges prominently. Don't do any investigation. Put it completely out of your mind till you come back this afternoon. This afternoon, we can kick up at 1:30.
1:30, George.
1:30. So we'll have the door open before that. Hopefully you'll all be back on time so that we can get started right at 1:30. Okay, thanks everybody. Just leave your notebooks on your seat. Is there anything to address on the record before we break?
I would just, for purposes of planning, inform the court that I only have one more witness.
Okay.
Great, we'll be ready to go.
Okay. We'll see you back at 1:30. Thank you, everybody.
pattern of the sweater was taken after 9 p.m., after 9:20 p.m., which is after prosecutors said they arrived back at Maxwell Anderson's home on that same night. And then this particular photo was one of the batch of photos that they say was deleted from Maxwell Anderson's phone between 12:05 and 12:08 a.m., which would be about a half hour before prosecutors believe he left the house in Sade Robinson's car and started driving around the city. One other thing, there's another photo we cannot show you because there was just no way to edit it sensitively, and that is what we are told was Sade Robinson's pants and underwear being removed from her body on Maxwell Anderson's couch. And as it was seen in court and as it's been described by witnesses and by also our own Stephanie Quirk and others who were there, there was these light-colored blue jeans that you see here. This is what was recovered from the burning car, Sade Robinson's burning car on the north side of Milwaukee on April 2nd at 7:30 in the morning. These were in the trunk. The trunk didn't burn. The inside of the car did. The trunk did not burn. These were recovered. You see the yellow bikini underwear that is right around kind of the knees, wrapped outside the legs. They say that is how, the prosecutors say that is how the clothing was found, and they say it's consistent with someone else removing those clothes. Now an image has been shown in court which shows these jeans and underwear that looks like that being removed from what appears to be Sade Robinson's body inside Maxwell Anderson's home. I just got word that Maxwell Anderson is back in the courtroom, and we're hearing, okay, I'm hearing some things in the courtroom. We're going to send you back to the safety building now.
Ian Vance Curzan and Megan Newport appear for the state, joined at council table by Detective Joanne Donner.
Good afternoon, Your Honor. Maxwell Anderson with Anthony Cotton and Jason Finlay.
Newport appear for the state, joined at council table by Detective Joanne Donner.
Good afternoon, Your Honor. Maxwell Anderson with Anthony Cotton and Jason Finlay.
Okay, good afternoon, everyone. This morning we received an email, well, Attorney Cotton received an email. It was also sent, I believe, to the prosecutor as well as to myself. However, my spam took it and I never was able to see it. Attorney Cotton showed it to the state as well as to me, and it reflected comments regarding comments posted to, I believe, Law and Crime's website on YouTube, and a concern relative to that. The parties and I discussed it, and at the parties' stipulation, no further action was to be taken. Since this point in time, we've received further emails with the same information and attempts, I think, to contact my court as well as other courts. What we all know relative to the comments that are posted is some are accurate, some are inaccurate, some are made up, and Lord knows why people feel the need to post continuously. At this point in time, we've discussed it at length, and it's my understanding that the parties are stipulating to taking no further action. State, is that accurate? And is there any further record you wish to make?
That's accurate, and no.
Defense?
That's accurate.
Okay, anything further to address on the record before we resume?
No.
Attorney Cotton, anything further you'd like to address on the record before we bring the jury in?
No.
Okay. And let's address that ringing.
Yeah.
We'll go from there. Special Agent Ruff, you can come back up if you'd like.
Oh, sorry, Terry.
Yes, please. Oh, wait, we should recall it with new court reporter.
Recalling State of Wisconsin versus Maxwell Anderson, case 24, CF 1692, appearances.
Ian Vance Curzan and Megan Newport for the state, joined alongside by Detective Joanne Donner.
Jason Finling and Tony Cotton with Max Anderson, and also our private investigator, Jason Barber. Good afternoon.
Good afternoon. Good afternoon, everybody. Hope you had a lovely lunch. At this point in time, we are just about to begin cross-examination of Special Agent Ruff. We will re-swear him because we have a new court reporter.
Do you solemnly swear that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You could please be seated, restate, and respell your name for the record, please.
My name is Jason Ruff. That is spelled Jason, last name Ruff.
Please proceed.
Thank you, Judge. Good afternoon.
Afternoon.
So you just recently testified that your job really was to analyze two different devices, right?
Correct.
Like a cell phone, then also a computer.
Correct.
But so you examine like the hard drive in the computer, right?
That is correct. The forensic image of the hard drive.
Okay, and so you said you're like a forensic expert on these types of analysis, right?
Yeah, forensic examiner.
And one of the goal, I mean, I guess one of the reasons you have the job is because you need to analyze people who are accused of crimes, their electronic devices, right?
Either people accused of crimes, victims, really anything related to a criminal investigation.
And it's because electronics are a pretty complicated, it's complicated evidence, I suppose, right?
Yeah.
And you have all these tools that you listed in your report that you utilize these tools, and they can help decipher data from phones that you really wouldn't be able to get unless you had these tools, right?
Correct.
And so I'm gonna start with the cell phone. And so these tools you use, you're able to determine, pull text messages, right?
Correct.
And even if deleted texts, right?
Possibly, potentially.
And also you're able to look at someone's internet browsing, right?
Correct.
And that's something you did in this case, right?
Correct.
And you're able to determine what website someone went to, right?
Correct.
Even if they use like the private browsing, is that right?
Yes, for the most part, yes.
And so in this case, you reviewed all of that, correct?
Correct.
And you didn't see any searches regarding how to, dismember a body, correct?
I did not.
Or you didn't see any searches about how to clean up blood, correct?
I did not.
Or how to dispose of a body, right?
Correct, I did not.
Nothing about how to remove DNA from a surface, right?
Correct.
There weren't any searches whatsoever about DNA, right?
Correct.
And that's on the phone.
Correct.
And then also you have access to the map application, right?
Correct.
I think of Google Maps, but I'm not quite sure what's used on an Android, but there's some sort of map application, right?
Yes.
And I think the jury all knows, when you type in, if you're trying to go to someone's house, you type in the address, and then that gets saved on your phone, correct?
Correct.
And Max's phone, this device that you looked through, there was no GPS coordinates to Warnemont Park, correct?
I would have to re-look, but I do not believe so.
Okay. And I think you had testified that the phone, shut down at some period of time, right?
That is correct.
I think 1:35 a.m., that sounds right, on April 2nd?
Correct.
But the phone wasn't turned off. It shut down, but it wasn't a intentional act of someone holding the power button and turning it off, correct?
That is correct.
It's shut off because it has 0% battery.
That's correct.
So perhaps, the user fell asleep or forgot to plug it in, right?
Anything's possible.
And the data I guess you pulled, was there a certain time frame that you're looking at from this date to this date?
So the primary time that I was told was primarily the 12:45 a.m. to, I want to say 8, I would have to look specifically, but I believe it was like 8:50, 8:45 a.m. and just the time surrounding that.
Okay, so you're not looking at data like before April 1st, right? Oh, I guess you are, because I guess there's some text messages before that.
Correct, yes, yes.
Like, there's not, you weren't looking at data from like early, March or February, right?
Correct.
So if like the phone had the user had a repeated pattern of their phone dying, that's not something you would have seen.
Well, I did see that on the records, that ERP is just a long list of all the power events.
And it died on April 4th as well, right?
Yeah, it died on April 4th.
Okay, so more than once this phone is dying, right?
Correct,
It's not just isolated incident to April 2nd, right?
correct.
And then let's move over to the computer. You had explained that, well, so the phone, you said user interaction stops around 12:07 a.m.
Correct,
on April 2nd, right?
correct.
You said maybe to 12:08, but you're not sure, pretty confident 12:07 phone activity, human activity stops, right?
Correct.
And then right around that same time, Netflix or the computer, there's user activity on the computer, right?
That is correct.
So consistent with someone they cease interaction with the phone and start interacting with the computer, right?
Yeah,
And so 12:07, yes, according to, your analysis, activity stops with that electronic, but not all electronics in this residence, right?
yeah,
And because a Netflix show is played at 12:07, right?
correct.
And the show is played, and it sounds like these are probably pretty short episodes, right?
Yes, and from what I saw actually in some of the episodes for that Love, Death, and Robot show had been played the previous night as well.
Okay, but they're short episodes, like 10 minutes or less.
Yeah, like 5, 10, 15 minutes.
Okay, and in some of the photos, I think in your report, it looks like they're almost animated. It's like an animated show?
Yeah,
Okay. So it plays a few episodes back to back, right?
correct.
And could you determine whether a user was actually clicking next episode, or was it just kind of timing out and playing
It
repeatedly?
was timing out and playing the next episode.
Okay, and then after those shows stop playing, the user, so this is a user, human being most likely interacting, playing a new show at 12:28 a.m., correct?
Correct.
And again, that action is physically done by a human, right?
Yes, they would have to physically transition over to that episode, or that show, I should say.
Okay, and I think a lot of members of the jury probably use, streaming services is when you can either search it, or sometimes I think you said you can get a suggested show and it pops up. It's like a show you might like and you can just click watch and it plays, right?
Correct.
And these platforms like Netflix and Disney Plus, what have you, if you finish like a series, you don't even have to click watch a new series. Sometimes it'll just immediately queue it up and play it, right?
Depending on the browser you're watching it on, but yes.
Okay. And so 12:28 a.m., a new show is played, and that show is played in its entirety, correct?
Correct.
And you said that show's about an hour long, give or take?
Yeah,
And then after that episode ends, another episode is played, correct?
that's correct.
But that's actually auto-played.
Correct.
So it's not a user, because I think you can imagine it's the timer, that 10-second timer, 15-second timer.
Yes.
And it says you can either click play next episode, or you can just wait the 10 seconds, right?
Correct. I believe it's like 2 minutes or so on average.
Okay, so sometimes it's up to 2 minutes how long it waits. And so users don't actually need to click the button, they can just wait. Maybe if you're just don't want to pick up the remote, maybe you're lazy, you don't need to have to pick it up, right?
Correct.
I'm sorry, you don't have to pick up the remote to click the button, right?
Correct.
And so if someone fell asleep, for instance, the Netflix would continue to play, and the person doesn't actually have to interact with their TV, right?
That's correct.
And you say that according to, the data you analyze, the show plays until at least, did you say 2:35 a.m.?
Yes, I believe that was the time.
And then does another show play after that, or were you not be able to tell because something with like the internet?
Yeah, so there was an interruption in the network when what I talked about, that IP lease, happened around the time when it would start playing another episode, which very briefly disconnected from the internet, like probably fractions of a second, but just long enough to interrupt that auto stream. So, yes.
Do you know if more episodes were played after 2:35 or not?
There were no episodes played.
Okay,
after
so
2:30.
so the episodes are done at 2:35 a.m., correct?
Correct.
But nothing about the data or anything that you analyze can tell you whether the user stopped watching the show, right?
You mean like to click off?
Well,
of
like
the show?
the data you reviewed can't tell you whether someone's actually watching the show or if someone isn't watching the show.
Yeah, no, that's correct.
And then also, with your tools, you're able to look at internet searches, correct?
Correct.
On the computer, I mean.
Yes, that's correct.
It could be either Safari, Google Chrome, whatever internet, browser people prefer, right?
That's correct.
And in a part of your job and in your experience, you've seen in criminal investigations where a user is, looking up things that, are consistent with them committing a crime, right?
Correct.
Or trying to conceal a crime, right?
Correct.
And that goes back to what I was talking about earlier about, how to dispose of a body, right?
Correct.
And were you aware of any facts regarding this case before you started your analysis, or you just going blank?
Very brief facts, pretty much. I mean, nothing, like no real in-depth facts.
But had you seen like news articles about it?
Yeah, pretty much just whatever everybody else was seeing was what I knew about the case.
Yeah, everybody else, because it was over social media, Facebook, Instagram, right?
Correct. Correct.
And sometimes, if you look on your Instagram feed, you'll see, a news story come up, right?
Correct.
And when you looked at, this Max's computer, you didn't see any information about how to remove DNA or how to clean up a crime scene, right?
I did not know.
And again, forensic investigators often rely heavily on history to evaluate intent, correct?
Correct.
And again, you found no search history on the computer consistent with planning or committing a crime, right?
I did not.
And just briefly here, you said that there were photos deleted. You could conclude that, right?
Yes. Yes.
And you included some photos that were deleted in your report of Sade, right?
Correct.
But there was other photos that were deleted as well.
Correct.
Did you say there was 32 in total deleted?
So there were 32 cache photos. I couldn't tell you the exact number of actual photos deleted. The 32 cache photos correspond to the time frame when the deletion was actually occurring. So not every photo gets a cache image. And it depends on whether or not it's interacted with recently or really any number of things. So I wouldn't be able to say exactly how many photos were deleted.
And just to wrap up here, you also were able to pull the text communications between the two, right?
Correct.
And in those text communications, Sade Robinson's phone never sends Maxwell's phone her address, correct?
No,
Or the general area of the city where she lives, right?
not that I saw.
I have nothing further.
State,
I have nothing else.
thank you. State your next witness.
Dr. Karsten.
Do you solemnly swear that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please be seated. State and spell your name for the record.
My name's Dr. Jordan Karsten. It's Jordankarsten.
How are you employed?
I'm a professor of anthropology at the University of Wisconsin-Oshkosh, and I'm also a professional consultant for the Wisconsin State Crime Lab through the Wisconsin Department of Justice.
What do you teach at UW-Oshkosh?
I'm a biological anthropologist, so primarily my work is focused on the human skeleton. So I teach classes in human skeletal anatomy, teach classes in forensic anthropology, biological anthropology, genetics, sometimes archaeology, depending on what's needed.
Could you just briefly summarize sort of your background in training and education?
Yeah, so in terms of education, I got 2 bachelor's degrees from Grand Valley State University in Michigan. One was a Bachelor's of Science in Anthropology. The other was a Bachelor's of Science in Health Sciences. And then I got a master's from the State University of New York in Albany and a PhD in, my master's was in anthropology and my PhD is also in anthropology from the State University of New York in Albany.
How long have you been an anthropologist? I might have missed it.
How long? I graduated college in '09 and I graduated my PhD in 2014. And I've been a professor at UW-Oshkosh since then in 2014, so I've been in the state for 11 years.
Were you contacted on or about April 3rd of 2024 by the Milwaukee County Medical Examiner's Office regarding a leg that had been recovered?
I was.
What was the nature of that contact? Why were they contacting you?
I was contacted by Charles Rohr, Dr. Charles Rohr, who is a forensic pathology fellow at the Milwaukee County Medical Examiner's Office. He told me that a human leg had washed up on the shore at Warnemont Park in Cudahy, and that he was interested in having me examine part of the skeletal remains to look at if the individual was dismembered, how that might have happened, and look to see if there were any tool marks present on the bone.
So what was requested of you was an examination originally just of the leg for a tool marks analysis?
Correct.
Okay. And as well as just a general examination of the trauma to the skeletal remains to see if you could figure out what happened.
Correct.
Did you in fact examine skeletal remains from that leg?
I did.
And over the course of the next weeks and months actually, did you also come to examine additional skeletal remains that were recovered related to this case?
Yes.
Did you subsequently prepare a report to document what you observed and what your findings were?
I did.
I'm going to show you what's been marked as Exhibit 409.
I don't object to this for the record.
Okay.
And will be received into evidence?
All right, 409 is received into evidence. That's your report, Dr. Karsten.
It is.
I'm going to pull it up on the screen next to you, and I would like to go through it with you in summation. And while I'm pulling this up, can you tell the jury overall what bones did you examine?
I examined a right femur, which is essentially complete, part of a left femur, left tibia, left fibula, right humerus, right radius, and a right ulna, as well as 2 cervical vertebrae and a patella, which is the kneecap.
And are you able to discuss an overall pattern of what you saw through your analysis of these skeletal remains?
Yeah, so overall pattern is the majority of the remains had some type of blunt force trauma, which had fractured the bones. And many of the bones had cut marks, and the cut marks themselves were superficial. They had what I call a V-shaped kerf. The kerf is the incision on bone, and so it was shallow, shaped as a V, and fairly regular walls. And those cut marks were found at locations across different bones, primarily in places where there are areas of muscle attachment and connective tissue attachment.
Okay, and did the fact that those cut marks to the bones were in those locations suggest anything to you?
It's consistent with the manipulation of soft tissue and dismemberment.
Were you able to examine or come to any kind of conclusions as to what kind of blades were used?
All I can say is that whatever caused the sharp force trauma, the blade itself had a V shape to it, and it was not serrated. So a serrated knife, like a steak knife, will produce a kerf, a incision in bone that's irregular. And this incision was not irregular. It was kind of uniform.
On any of them?
For all of them. There was no irregular aspect to the curves.
And based on the size of those cut marks and V-shaped markings, are you able to come to any conclusions about the size of the knife used?
I can't. When a knife comes into contact with bone, depending on the level of force, how much the knife actually contacts the bone, it can be very small kerf. You can push harder, make the kerf larger. So I can't say anything about the size of the blade.
Only thing you can say is whether the shape and then whether it was serrated or non-serrated.
In this case, yes.
And how is it that you're able to tell whether it's serrated or non-serrated?
Serrated blades will create, if you think of a serrated blade like a steak knife, essentially, they'll create a more irregular kerf or cut on the bone.
You may have mentioned this, but can you give some examples of some types of non-serrated blades?
Sure, like a paring knife would be a good example. You have plenty of blades in kitchens that are non-serrated. Simple blades. I mean, you could have say a fishing knife you'd use to fillet a fish would also typically be a non-serrated blade.
Were you able to identify blunt force trauma to any of the limbs?
Yes, on many of them.
Okay. I'm going to go through this, and let's start with, we're going to start with the right femur. If you want to flip to that page or follow along on the screen to your right. Let's talk about what you knew about the right femur, what you discovered.
Sure. So for the right femur itself, it has evidence of blunt force trauma. I don't know if we can go forward. Is that possible? So if you go to figure 1, you can see the complete right femur. The black arrow is showing an area that's approximately where there would have been force applied to the femur. If you go down to figure 2.
And just to be clear before I do that, this would have been the right leg, the leg
This is
that
the
was
right thigh.
from
essentially,
Warnemont
the right
Park.
thigh bone, from Warnemont Park.
Okay.
So if you go down here, you can see a little bit closer on the right femur. The black arrow is the point where force would have been applied. And the way that we can reconstruct that is that bone is stronger in compression than tension. And so when blunt force trauma is applied to a limb, it causes a bone to bend. And in that process, the area that when it bends and goes into tension, that's where a fracture will start. And from the point in tension, the fracture shears over to the compression side. So can I point at this?
Yes, I think there's actually a microphone next to you if you can turn that on.
Okay. Does that work? Maybe not. Okay, that works. If you take a look here, you can see that if force was applied here, the bone would have bent, kind of bowed out like this, and then you would have had that area of tension right there where the fracture starts, and it shears over to the other sides. And then what happens is it removes this kind of rhomboidal shaped, or what often gets called lozenge of bone, and so that broke free. And so on the right femur, in this case, we actually have 3 different pieces of bone that result from this fracturing. One that's here that includes the femoral head, which goes into the hip socket of the pelvis, this lozenge shape of bone, and then the larger part, which includes the entire rest of the femur.
Would a person be able to apply the force necessary to cause this damage?
Yes, depending on the person and the circumstances, I believe, yeah.
You believe yes? Okay.
Correct.
Are you able to comment on the difficulty to cause this fracture?
It would be difficult, but it would be possible.
I'm going to move to strike that. In the last 2 answers and questions, he's not a use of force expert. I don't think he's been qualified in this topic that we're going into.
I can ask him some foundational questions.
Okay, lay the foundation.
Do you have any expertise in being able to determine what kind of force needs to be used to fracture bones in this fashion?
As part of my job with the Department of Justice for the Crime Lab, I will remove pieces of bone for subsequent chemical and genetic analysis. And so, yeah, I'm familiar with what is required to break bone.
I would ask then the objection be,
Withdrawn.
okay. All right, so let's pick up where I was left off here. On this part, on this femur bone, were there cut marks?
Yes.
Is this the good figure for that, or is there a different?
If you could move forward to figure 7. So on figure 7, you can see a close-up of the lozenge shape of bone. And then on the opposite side where the black arrows are, you can see a series of superficial cut marks. These are on an area that's called the linea aspera, and it is an area of muscle and connective tissue attachment.
And would that's the location of those cut marks suggests what soft tissue would have been being cut?
There are many, many muscles and aspects of connective tissue that connect there. You couldn't say exactly what.
What part of the body is this, I guess?
This is on the posterior side of your thigh.
So by your hip?
Below that.
Below your hip, okay.
Back of the leg, essentially, back of the upper leg.
Let's go to figure 11. How about this one?
Yep, figure 11 shows additional cut marks. So the black arrow shows like a roughly kind of horizontally oriented cut mark. In the red circle, there are additional cut marks, superficial cut marks, and then in the black circle, hard to see, but there are additional very faint cut marks.
Would the cut marks that you noticed when you examined the bones from the right leg from Warnemont Park, would that have been consistent to have been logically been in an effort to remove soft tissue?
Yes, it's in the area that's close to the hip.
Okay, the top of the leg.
Correct.
Are you able to tell whether the blunt force trauma to the bones, like we saw before, occurred before or after the sharp force trauma to the tissues?
For these, I cannot say.
You are able to conclude that it was the blunt force trauma that caused the fractures?
Yes.
All right, anything else about the right femur?
Figure 12 shows an additional couple of cut marks.
Okay.
This is on the front side, anterior side of the femur, in an area that's known as the intertrochanteric line, which is another area of ligamentous and muscle attachment. If you go to figure 13, you'll see even more cut marks. This is on the lateral side of the proximal femur, so the part that's closest to your hip. The black, red, and blue arrows all point to individual cut marks on that figure. And then on figure 14, up on an area that's known as the greater trochanter of the femur, which is another muscle attachment and area of connective tissue attachment, you can see more cut marks, superficial ones with the red arrows, and then with the blue arrow, you can actually see one where the cut mark has kind of peeled back the bone. And so that cut mark must have been delivered in a kind of above body to below, so what we call superior to inferior direction.
Would it be fair to say that the cut marks you observed were generally concentrated, towards the transection end of the leg?
Not just I wouldn't say like in the hip.
Okay.
It's from kind of the upper third of the leg is where we are finding the cut marks.
All right, let's move on to the left tibia. What did you observe about the left tibia?
The left tibia has one aspect of blunt force trauma. So if you look at figure 16, you can see the tibia is separated and the tibia is the shin bone. Figure 16, that's the upper part of the tibia. So that kind of plateau area is what makes up your knee. And then if you go down to figures 18, you can see on the left, that's the upper part of the tibia. In the middle and removed, that's this lozenge shape of kind of rhomboidal shaped bone that gets removed during bending fractures caused by blunt force trauma. And then on the right is a shaft of the tibia. And then if you go to figure 19, you can see without that lozenge shape, how it goes back together. And if you go to figure 20, you can see that lozenge shape is replaceable into the break. And so in this case, if you could go back to figure 19 quickly, where that black arrow is, that's where the force would have been applied. So this is on the medial side, so the inner side of the leg, with the force moving from the inner side of the leg to the outer, what we'd say is medial lateral force. And so it broke on the far side away from the arrow.
You use the term butterfly fracture here in the description. What is that?
Butterfly fracture is a term we just use for these fractures where bending of the bone has that lozenge-shaped breakaway. And so it tends to break away this rhomboidal piece of bone that kind of looks like one wing of a butterfly.
Okay.
Sorry.
I was just going to ask you whether there were cut marks to the bone that would have separated the bottom from the ankle.
Yeah, if you go to figure 22, this is the bottom part of a fibula. So this is where your shin bone comes into contact with your ankle. And you can see with the black arrow, one of these superficial cut marks across that part of the bone. If you go to figure 23, you can see additional, this is twisting the bone around a little bit. You can see additional cut marks highlighted with the arrows and an area of bone that was damaged in the black circle. And if you go to figure 24, this is twisting the bone around to what's known as the medial malleolus. So this is like the big bump on the inner part of your ankle. You can see another couple of superficial cut marks there as well. So cut marks around the distal part of the femur, lower shin bone.
All of these cut marks, these superficial cut marks, all the ones we're talking about, these are all from some kind of a non-serrated V-shaped blade?
Yep, they're what we call V-shaped kerf. So they're superficial, they don't go deep into the bone, and they don't show any hallmarks of being serrated because the kerf is not irregular.
Intentional cut marks?
There's only one way to cut into bone, and that's by purposely putting a knife there.
An only way to cut it, one way to cut into tissue as well.
Correct.
Let's move on to the left fibula. What did you notice?
Left fibula has 2 instances of blunt force trauma. If you look at figure 25, you can see with the black arrows, the area where the force would have been applied. And it's just like the pictures we've seen so far. It's these butterfly fractures, bending fractures. In this case, the force would have been applied anterior to posterior. So the fibula is a bone that is in your lower leg. It sits next to your shin bone on the outside of your shin bone. And so those 2 areas of force didn't actually have enough force to cause the bone to completely break. And so you can't remove those lozenge-shaped pieces of bone. That bone still is a single element that's not separatable.
And regarding cut marks on the left fibula?
There's a single cut mark in figure 28. So this is an area that's just above what's known as the lateral malleolus. And so that is the bump on the outer side of your ankle. And just above it, where the black arrow is, you can see another one of these kind of horizontally oriented superficial cut marks with a V-shaped curve.
Anything else about the left fibula?
No.
All right. The right humerus, what's the humerus?
Humerus is the bone of the upper arm.
Let's talk about the right humerus.
In this case, in figure 30, you can see the head of the right humerus. This is what makes up your shoulder joint from your upper arm. Only that is present here, and there is a fracture to the bone that's removed it from the rest of the humerus.
Is the removal of the humeral head evidence of blunt force injury?
This likely is, yes.
Okay. Let's go to the left femur. This was let's talk about the left femur. Go ahead.
Okay, if you go to figure 34.
Sure.
The proximal left femur, so the part that's closest to the hip, the head of the femur, what goes into the hip socket, is preserved, as well as part of the neck of that. But then there is what we call a comminuted fracture. And so you've got a blunt force impact that has taken the bone there and broken it up into many small pieces. And so that has destroyed, although those fragments are still adherent, the lateral side of this femur. And so force was probably applied in a superior, so upper lateral down to inferior medial, so kind of direction.
Okay. Any cut marks?
On this part, the superior part of the left femur, no. If you go to figure 36, you can see additional aspects of blunt force trauma. So the black arrow shows blunt force trauma that removed a lozenge shape of bone, but that was never recovered. And then the red arrow shows another one of those fractures, just like we've seen in the other pictures of this kind of butterfly fracture that was also applied to the femur. And then at the very far right side of the picture is another one of these bending butterfly fractures caused by blunt force trauma. And so in this femur, we've got at least 4 instances of blunt force trauma to the left femur.
And how many of those instances were consistent with the right femur?
They're in very different places than the right femur.
Okay. Any evidence of cut marks?
Yes, if you go to figure 42. So every black arrow is a superficial cut mark on the anterior femur. There's at least 11 superficial cut marks there. In this picture, there are 7 that are highlighted. If you go to figure 43, you can see one of these a little bit more close up. In this case, that cut mark exhibits what we call kerf flare. And so that is where you can see the cut marks are almost superimposed one on the other. And this is something that you see when a non-serrated blade is used in a sawing motion.
All right, so this was evidence that there was a sawing motion to cut the tissue around the femur.
Correct.
Okay. All right. In June, much later, you had received bones from the right arm that had washed up in Waukegan, Illinois, correct?
Correct.
All right. Let's talk about that right arm. What did you notice?
If you go to figure 46, in the area with the black circle, you can see cut marks that are on the side of the humerus, the proximal humerus, so it's up towards the shoulder. On the medial side, so the side that's like kind of towards your armpit, there were no cut marks. If you go to figure 48, you can see that on the kind of lateral posterior side, there are additional cut marks highlighted in the black circle. These are kind of difficult to see, so if you go to figure 50, there's I'll go up actually.
Sorry.
Yep, there's a close-up picture here of the cut marks on the humerus. And so you can see here several of these V-shaped curved superficial cut marks on the proximal humerus. So this area is known as, this includes the greater and lesser tubercle of the humerus, and these are areas of muscle attachment for the shoulder.
Was there similar indication on these of a sawing motion being used?
Yeah, some of these curves are kind of superimposed one onto the next, and so likely reflects sawing motion.
And that would have been an intentional act?
Yes.
All right. How about the radius?
If we go to the radius, if you could look at figure 57.
57, okay.
So the radius is a bone in the forearm. And on figure 57, you can see the black arrows highlighting a single superficial cut mark on the distal part of the radius. This is the part that's towards your wrist. If you then go to figure 61, you can see a close-up of that. Could you go up just a little bit, I guess?
Sorry.
Yeah, you can see a little bit better that superficial cut mark. If you go down to figure 62, you can actually see a good example of kerf flaring. And so that's where you've got this cut mark, but on the end, the kerf, there's actually a couple of different tracks to that knife. And that, again, is something that's consistent with using a non-serrated knife in a sawing motion. And then in figure 63, that close-up gives a good example of what I mean by a V-shaped kerf. That's this incision in the bone, takes on a V shape, but it has a very regular floor to the kerf, which is something that you see in a non-serrated blade.
So the person who caused these marks that I'm looking at here in 62 was intentionally sawing at the bone with a non-serrated blade?
They were sawing at the bone with a non-serrated blade.
Any cut marks near the elbow?
No.
And you had looked at the, anything else on this,
For the ulna?
the right arm?
Yep, so the ulna is another bone of the forearm, makes kind of the inner part of the forearm. And if you go up actually just a little bit, at 67? Okay, 67 shows the location of two of these superficial cut marks on the ulna. This is the distal part, so the part like towards where it's at is towards the wrist. The part on the left side of the screen is towards the elbow. And if you go to figure 68, you can see them a little bit close up there, the superficial cut marks on the distal ulna.
Anything else on this one?
No fractures to the ulna or the radius.
You examined some of the cervical vertebrae?
Yes.
Okay.
I was given two cervical vertebrae to examine.
And where were those from on the body, if you could just help us
Cervical
out?
vertebrae is the vertebrae that make up your neck.
And what did you notice when you looked at the cervical vertebrae?
No evidence of cut marks. The only trauma was on the most superior of the two cervical vertebrae. And if you look at figure 69, you can see that on the right side of the cervical vertebra, on a feature that we call the transverse process, there is damage to the top of it, highlighted with the black and red arrows, and that's likely caused by blunt force trauma.
Blunt force trauma?
Likely, yes.
And lastly, the patella. What is the patella?
Patella is the kneecap.
What'd you notice?
No evidence of trauma or cut marks.
That was from the left leg?
Let me double check. Yes, left patella.
Are you aware, or can you speak on the time frame it would take a person to cause the damage that you analyzed in these figures?
I don't think I could give an estimate of that.
I have nothing else.
Ross?
What you can give an estimate on is just how difficult it is to remove bones from a human body without the right tools, right? You can take that down again. Okay.
I have never, I mean, I've removed bones from each other with tools.
Right.
Yes.
What types of tools?
If I was going to separate two bones from each other for the purposes of an examination, I would use a scalpel. To get through soft tissue.
Right, to get through soft tissue.
Correct.
So I thought before you had said you have experience removing bones from a human body, no?
I've experienced removing bone from bone, like breaking off a piece of bone for sampling, and separating bones from each other for the purposes of analysis.
Okay, so you've taken two bones apart on occasion for your work.
Correct.
But you've never done an autopsy.
Correct, I'm not a pathologist.
Okay, and are you able to speak to how much force is required to remove bones from a human body?
Yes, I mean, for me, when I do it, I typically use something like a small Dremel tool, and we can use that to remove pieces of bone from the human body, so a small motorized saw.
Okay, a small motorized saw.
Correct.
What do you
remove
weigh?
small pieces.
Okay, and what do you wear when you do that?
Protective glasses, protective mouth and nose coverings.
Why?
I would rather not breathe in bone dust.
Okay, bone dust would get on you.
If I was using a saw, correct.
And if you're removing a bone, if you're cutting through flesh, you could get bodily fluids on you.
Correct.
Blood,
Yes, correct.
other such fluids that would just be within the body, right?
Correct.
Would be a very messy process to dismember a body. You would agree with that?
Depending on the condition of the body, yes.
Right. If a body was newly deceased in particular, it would be particularly messy.
I don't have experience with that.
You have no experience with dismembering, taking body parts off of a newly deceased body.
No, anthropologists tend to get involved when there's considerable decomposition or a complete skeletonization.
And obviously things become weaker with age, right? Things degrade.
Depends on the context of deposition.
Well, but you would agree with that proposition, wouldn't you? That bones don't get stronger as they over time.
I actually disagree with that. So if you have a bone that's deposited in like say a soil matrix that has a large mineral content, I have excavated personally bones that are 6,000 years old that are heavier, beefier, and stronger than fresh bone.
Got it. Here we're talking about new bones that are not 6,000 years old, sir.
Correct.
Okay. So these bones, as you understand it, were the bones from somebody who is recently deceased. You understand that, right?
Yes, definitely.
And that the bones were located out in nature, right?
Yes, correct.
Not in a special soil matrix.
Correct.
And they were found in various parts of nature, water, the woods, things like that.
That's my understanding, yes.
And all I'm asking you is, would you agree with me that as time goes by in those conditions, things will tend to degrade?
Yes.
Okay. Now, the size of the knife, or if it was a knife, you have no idea if it even was a knife, do you?
It's a sharp blade.
Or it could be an axe.
It would be very unlikely to be an axe.
It could be an axe.
To make those kind of cut marks would be very, very unlikely.
Well, that's for the cut marks. But for other parts of what you looked at, it could be an axe for other things.
For the blunt
right?
force trauma, that would definitely be a possibility.
Right, where we're seeing the bone itself literally fractured, right?
Correct.
Because when you're telling the jury about blunt force trauma, you're talking about one of the exhibits we saw was literally part of the proximal right femur broken off, right?
Correct.
So you wouldn't rule out an axe on that?
No, not at all. Axes can impart blunt force trauma because of their wedge-shaped action. And so if an axe is used and is applied with force to human bone, it doesn't necessarily make a cut. It can result in strictly blunt force trauma.
Were you given pictures of items that were recovered from, you understand Mr. Anderson's accused of this crime, right? Do you
Yes.
understand that? Were you given pictures of items that were recovered from Mr. Anderson's home and asked to offer an opinion? Let me finish. About whether these items were used in this dismemberment?
Not that I have any recollection of.
So no,
Correct.
no axe given to you to say, was this used?
No, never.
Or pocket knife or anything else?
No.
And we'd have to ask you said a forensic pathologist could speak more intelligently about the level of force you required to fracture bones, right?
Yes, I would think so.
For example, when you talked about the proximal right femur, you know that it's a lot of force needed to break a femur bone, right?
Correct.
How many hundreds of pounds of force, or you can't speak to?
I couldn't say, in that bone and its mechanical properties varies person to person.
Some bones are stronger than others, just
Also
because
true.
of their calcium concentration, right?
Sure, yes, correct.
And what you do know, or what you've been able to identify in your report, is basically, let's just go to the bottom line conclusion. Bottom line conclusion is that some sort of sharp instrument was used to remove bones from a body.
Yes.
Okay, you can't say that Mr. Anderson did that.
No.
You can't say who did it,
Correct.
or where it happened,
Also correct.
or even the item that was used for it.
Also correct.
Okay, that's all.
State.
I have nothing else.
Thank you, Doctor. State.
The state has no more witnesses. The state rests.
Okay. At this point, I need you to put your notebooks on your chairs, and you need to give me a couple minutes to address some matters, then we'll be back with you. Okay? Thank you, everybody.
Move to dismiss at the completion of the state's case, Your Honor, on all charges, but specifically, I want to raise a multiplicity challenge to the newly added charge of hiding a corpse. We started with the mutilation of a corpse charge. The state amended the information, of course, before we began raising a multiplicity challenge. I think that these are essentially in this context, with the same victim, the same body, essentially the same crime or the same elements, if you will, and I think one should be struck.
The hiding and the mutilating are two different acts. And so there's not they don't have the same elements. They're two different crimes and require two different criminal acts. Certainly they can overlap, as I think the evidence showed they did here, but those are two different crimes. So that would be my response to that.
Just a moment. Okay, so relative to multiplicity. Multiplicity exists when a defendant is charged in more than one count for a single offense. And the double jeopardy provisions of the state and federal constitutions protect a defendant from being punished twice for the same offense. Under Wisconsin law, we employ a two-pronged test to determine whether charges against a defendant are multiplicitous in nature. First, whether the charged offenses are identical in law and fact. And second, if the offenses are not identical in law and fact, whether the legislature intended the multiple offenses to be brought as a single count. In this particular case, the defense is arguing that the two counts relative to hiding or burying a corpse is charged in count 4, and count 2, mutilation of a corpse, are multiplicitous. So looking at the elements, which is one of the standards that has to be reviewed, I need to look at whether or not the offenses are identical in law and fact. As to the mutilating a corpse, there are two elements. It's first that the defendant dismembered a corpse, and second that the defendant dismembered the corpse with the intent to conceal a crime. Looking at count 4, the two elements of hiding or burying a corpse are one, that the defendant hid a corpse. Second, that the defendant hid a corpse with the intent to conceal the crime. There clearly are different elements in law relative to the two offenses. As to the difference in fact, there are different acts that would be different actions that would be involved in dismembering a corpse versus hiding a corpse. So I think in this particular matter, the two offenses are not identical in law or fact. I next need to look at whether the legislature intended that multiple offenses be brought as a single count. And in so doing, you look at whether or not the legislature, in the drafting and creation of the statutes, set out different elements under Blockberger that amounts to the fact that their intent was to allow for different crimes to be prosecuted under the same subsection. At this point in time, looking at the facts and looking at the law and doing an elements only test, I am going to find that the two offenses moving forward are not multiplicitous and that they are allowable. So I'm denying the defense motion relative to multiplicity. Defense,
Yes, I made a motion for directed verdict on all counts, Your Honor.
do you wish to make any further argument?
No.
State.
Not unless you would like an argument.
No. So what I can tell you, Mr. Anderson, is at the close of the state's case in chief, what the court has to do is has to look at the evidence in the light most favorable to the state. So looking at the evidence in the light most favorable to the state, was the evidence adduced, believed, and rationally considered sufficient to prove guilt beyond a reasonable doubt? Or in other words, has the evidence that's been presented during the course of this trial in the light most favorable to the state of Wisconsin, could a reasonable jury find you guilty? Looking at the facts underlying this matter, the evidence that's been presented during the course of this trial to some extent would be that on April 1st, you were at the Twisted Fisherman with Sade Robinson, that you arrived at 5:09, that she arrived at 5:20, that you both left the premises at a 6:24, that you then proceeded to Duke's on Water, arriving at 6:35, leaving the establishment at 9:04 p.m., that you proceeded to Anderson's home, 3161 South 39th Street, and arrived approximately 9:20 p.m. What we know is that on April 2nd of 2024, at Warnemont Park, at 2:53 a.m., the Civic arrived. At 4:32, the Civic departed. We know that on that same day, the leg of the victim was found. What we also know is that we watched a number of videos that tracked the progress of the vehicle, the Civic, around different aspects of Milwaukee. The videos at no point showed the driver or whether the driver was the sole occupant in the vehicle, at least not clearly. At 4:44 a.m., there was a white spot at a window and a lighter flashing or a lighter appearance in the driver's seat. Whether the white spot was a white hand or the white shadowing was a white person in the driver's seat, or whether that was a glove, that's going to be left to the weigher of credibility. At 7:30 a.m., we know that the Civic was set on fire behind the abandoned building. We know that the seat was in a position that fit a person who's 6'1". We know that your measurements are that on the time this happened, you were 6'1" and a weight was approximately 180 pounds. We heard the testimony that the value of the Civic was approximately $20,000. And based on the videos that were presented, a reasonable jury could conclude that that was you, that was in an approximate distance from the burning vehicle, that you left the area of the burning vehicle shortly after it appears it was set on fire, that you traversed and entered a bus at 8:07 a.m., that you exited the bus at 8:34 a.m., that you were arrested on April 4th, and during the course of the arrest, you were visibly shaking. On April 4th, 5th, and 16th, search warrants were executed at your home. At Galena Park on April 5th, there were parts of the victim that were recovered in the form of different pieces of flesh as well as a left foot. There was blanket found, small flesh, bone, and large piece of human leg on the 6th, and there were ball joints with ligaments recovered on the 7th. From the testimony that was adduced during the course of this hearing, I don't think those bloody gloves that were found on April 9th had anything to do with anything. And we know that the torso with the arm were recovered on Marina Road on the 18th. We heard the testimony from the medical examiner that the death was homicide by unspecified means. And we heard the Life 360 and phone information and tracking information, which reflect that the phone of Sade remained at your house until 9:24 p.m., that the phone ultimately thereafter was not stationary, that it went down Capitol to the Mitchell Parkway to Warnemont Park, remained static at Warnemont from 2:40 to 4:33. It was in Warnemont Park, I believe from 3 to 4:30 a.m. The last communication with the phone was on East Howard when the battery died. We know that Sade was reported missing on April 2nd, that you were the last person in communication or in presence publicly with her, that the videos of your home were poor quality. The testimony by Detective Rachel Smith was noteworthy. She indicated that she spent hundreds of hours viewing this video of your house and watching those hundreds of videos. And she basically saw the arrival at 9:20 p.m. and that the Civic departed on April 2nd at 12:47 a.m. She went through all of the testimony relative to the timing, about the gate opening, the outdoor movement and gate not opening, the silhouette exiting the gate the same size as the fence at 11:25, the light going out at 11:27, 11:42 a person goes into the premises, the motion light goes on for human movement with a person the size of the fence at 11:56. At 11:58, we have human movement at the back gate area. At 12:12, we have the gate closing again. 12:42, we have human movement inside the premises. And ultimately at 12:47 and 20 seconds, we have the Civic leaving the house. We also have the fact that on the bus video, you return to your residence at 8:42 a.m. wearing the green hooded sweatshirt and dressed differently. We have the fact that you went to the dugout on the following day for work. Noteworthy, we have the photos that were recovered from your home. It's noteworthy that the photos of Sade reflected her buttocks and her underwear pulled down as if the underwear were pulled down with the pants and that it rolled over the pants, which is pretty much just how they were found in the trunk of the vehicle that was set on fire, that you were found walking away from. We also have the fact that there's a photo of a white hand grabbing her right breast, and the right breast is the breast that was dismembered from her body on the torso that was recovered. We also have the fact that there was the photo of bleach and what not to combine with bleach, which I think a reasonable inference could be that someone on your phone was looking for information relative to how to clean up something or a crime scene. So looking at all of these factors together, it's a circumstantial case, but as we know, according to our jury instructions, circumstantial evidence may be found to be stronger than direct evidence. And at this point in time, I am going to find that a jury acting reasonably could convict you on all charges as posed. So I'm going to deny the defense motion, and what that means is I'm going to allow this matter to proceed to the jury. They have a different balancing than I have. So at this point, my view is, in the light most favorable to the state, do they have the means to convict? A jury at the conclusion of the case, their job is to determine whether or not the state has proven each and every element beyond a reasonable doubt. So I deny the defense motion. Have you spoken to your client, or do you need a moment to speak to him?
No, 1 minute, please. Okay, I've spoken to him.
Okay. Have you spoken with your client relative, well, let me ask you this. Do you intend to present any witnesses other than the defendant?
Defense rests.
Okay. So, Mr. Anderson, have you discussed with your attorney your constitutional right to testify as well as your constitutional right not to testify?
Yes, Your Honor.
And has your attorney answered all your questions?
He has, Your Honor.
And you understand that in a criminal case, you do not need to prove your innocence, but the state must prove your guilt beyond a reasonable doubt. Understood?
Yes.
And you understand that if you choose to testify, you would be subject to cross-examination by these prosecutors.
I understand.
And you understand if you choose not to testify, that cannot be commented on by anyone. That cannot be used against you. Understood?
Yes.
And have you had enough time to discuss this decision to testify or not to testify with your lawyer?
Yes, Your Honor, I have.
Have your attorneys provided you with their professional opinion?
They have.
Has anyone, including your lawyers, made any promises to you or offered you anything to arrive at this decision?
No, Your Honor.
Has anyone, including your lawyers, threatened you or coerced you in any way to arrive at this decision?
No.
Do you believe you're making this decision freely and voluntarily?
Yes.
Do you have any questions for me about this decision?
No.
Do you believe you're doing this with full understanding?
Yes.
Have you used any drugs or alcohol in the past 24 hours?
No.
Are you taking any medication that would affect your understanding of these proceedings today?
No.
After thinking through everything we just talked about just now, is it still your decision not to testify?
That is my decision.
Attorney Cotton, have you discussed with your client his constitutional right as well as his right to testify as well as his constitutional right not to testify?
Yes, just to be clear, it's been a subject of course discussion throughout this case, including the last 2 nights after trial. We've had jail visits to discuss that. Mr. Finling and I have both discussed it with him.
And are you satisfied he understands what his rights entail?
He does.
And have you advised him of your professional opinion?
Yes.
And are you aware of anyone making any threats or promises, using any force or coercion towards him in respect to this decision?
No, I'm not aware of any such threats.
Are you so satisfied that he's making his decision freely, voluntarily, knowingly, and with full understanding?
Yes.
I am as well. I in fact find that the defendant is waiving his right to testify, and he's doing so freely, voluntarily, knowingly, and with full understanding. Let's proceed at this point in time to do a conference relative to jury instructions and verdicts. I've printed off new verdicts for you. Prior to the matter being called, the state indicated they were seeking a lesser included on count 1. I did add in 1018. Is that still the state's position?
It is.
Defense, did you wish to be heard on that?
Yes. Give me 1 minute, please.
Okay.
It's a new development. Okay, no, I don't need to be heard on that, Judge. I don't have any, I've discussed it with Mr. Anderson, and I don't have an objection to that.
It's basically what I need to look at is whether or not a jury acting reasonably based on the evidence presented during the course of the trial could come to a reasonable decision on a lesser included. And that's the analysis the court has to make when a party requests a lesser included. In this case, I find it's appropriate, and I will add in the lesser included, so we will use 1018. So my intention relative to the instructions would be 100 opening instruction, 115, 1 defendant, 4 counts. Count 1, 1018, first degree intentional, followed by first degree reckless. Then moving on to 1193, mutilating a corpse. 1408, arson of property other than a building. 1194, hiding or burying a corpse. Then proceeding on to evidence defined, 103. Then 147, improper questions. 148, objections of counsel, evidence received over objection. I don't think I ever struck any testimony. Did I?
I think
It was asked, but then I think you withdrew.
Yeah, I don't recall any testimony being stricken.
Attorney Cotton?
Yeah, there was one comment where a witness had said they instead of the civic. That was struck, but
I'll leave it in. It's it's 2 sentences.
yeah.
157, remarks of counsel. State, I'm sure you want 170, circumstantial evidence, and 172, circumstantial evidence, flight, escape, concealment.
Yes.
Then 190, weight of evidence. 195, jurors' knowledge. I put in 200, opinion testimony. I took out the word expert because I think that's inappropriate to have in the title. 141, I assume the defense is requesting.
Yes.
201, opinion of a witness. I put that in relative to Detective Donahue's testimony when he was providing an opinion as to his hearing of what was the audio portion of the video. Any objection to that?
No.
And that's,
201.
no, I know that. There's also the recordings played to a jury 158
So I just,
covers that, which would cover that.
okay, I can put that in if you'd like me to. I think that it doesn't add much to anything, but I'm happy to.
I think
Okay.
it's redundant.
Yeah.
And what the jury needs to be instructed on is covered in 201. Or, yeah, 201.
Do you want 158 or do you want to just stand with 201?
No, I think I was just pointing out it's essentially covered under 201, so that's fine.
Okay, so you're not requesting an additional one.
Right.
Okay, then I did put in opinion testimony. Again, I took out expert and I put in the hypothetical question because there were a couple of hypotheticals posed. I'll remove 327 because the defendant didn't testify. We had one witness with a prior conviction, but was the question ever asked if he had a prior conviction?
No, it wasn't relevant.
I did not ask him.
And I don't think defense did either. So I'm going to take out 325. Is the defense requesting 315?
Yes.
Okay. 315 is in. I wasn't sure how the evidence would come in, whether or not 247 applied or not. And I'm thinking it does not, unless either side wants it.
I don't think it applies.
No.
Okay, it's gone. Then 300 credibility of witnesses, taking out the paragraph that would only have applied had the defendant testified. Burden of proof and presumption of innocence, closing arguments of counsel, closing instructions, then verdict submitted, and you'll see that I modified 484 to meet the lesser included, and that'll match the verdicts that are in your possession at this point. Then 515 unanimous verdict. Any additional instructions state or modification state seeking?
No?
Defense?
No.
Okay, I'm going to print you each a fresh copy. It is 2:53. I think we have plenty of time left in the day.
I'm ready to go.
Awesome. Then I'm going to give you 7 minutes, and then we'll start at 3 o'clock with closing arguments. Do I need to set a time limit?
30 minutes would be fine for each of us, I think we discussed.
I do 45.
I'll give you each 45 minutes as a max to be utilized between initial and rebuttal.
Right.
Fair?
Yep.
Okay, I'll print you fresh copies, and we'll start in 7 minutes. Okay, we are back on the record. Notebooks down towards Deputy Benz, please. So when you were last here, the state rested, subject to rebuttal. Does the defense intend to present any case?
No witnesses, Your Honor.
Then at this point in time, I'm deeming the evidence closed. So here's the plan for the afternoon. It is 3:05. I'm going to read to you the instructions, and then we're going to go into closing arguments. I've set time limits because I think it'll help on this case. So each side will have in total a maximum of 45 minutes to utilize during their closings. That's going to get us pretty close to 5 o'clock, and then we'll come back tomorrow for deliberations, okay? So, members of the jury, I will now instruct you upon the principles of law, which you are to follow in considering the evidence and in reaching your verdicts. It is your duty to follow all of these instructions. Regardless of any opinion that you might have about what the law is or ought to be, you must base your verdict on the law that I give to you in these instructions. Apply the law to the facts in this case, which have been properly proven by the evidence. Consider only the evidence received during this trial and the law that I give to you in coming to your conclusions and your verdict in this case. If any member of this jury has an impression of my opinion as to whether the defendant is guilty or not guilty, you should disregard that impression entirely and decide the issues of fact solely as you view the evidence. You, the jury, are the sole judges of the facts, and I am the judge of the law only. Now, the first count of the information in this case charges that Maxwell Anderson, on or about Tuesday, April 2nd of 2024, in Milwaukee County, did cause the death of Sade Robinson, another human being, with the intent to kill that person, contrary to Wisconsin statutes. To this charge, the defendant has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. The defendant in this case is charged with first-degree intentional homicide, and you must first consider whether the defendant is guilty of that offense. If you're not satisfied that the defendant is guilty of first-degree intentional homicide, you must consider whether the defendant is guilty of first-degree reckless homicide, which is a less serious degree of criminal homicide. Now, the crime referred to as first-degree intentional and first-degree reckless homicide are different types of homicide. Homicide is the taking of the life of another human being. The degree of homicide is defined by the law, depends on the facts and circumstances of each particular case. Both intentional and reckless homicide require that the defendant cause the death of the victim. First-degree intentional homicide requires the state to prove that the defendant acted with the intent to kill. First-degree reckless homicide requires that the defendant acted recklessly under circumstances which showed utter disregard for human life. It is for you to decide of what type of homicide the defendant is guilty, if guilty at all, according to the instructions which define the two offenses. Now, first-degree intentional homicide is defined in 940.01 of our criminal code and is committed by one who causes the death of another human being with the intent to kill that person or another. Before you may find the defendant guilty of first-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. One, that the defendant caused the death of Sade Robinson. Cause means that the defendant's act was a substantial factor in producing the death. Two, that the defendant acted with the intent to kill Sade Robinson. Intent to kill means that the defendant had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being. While the law requires that the defendant acted with the intent to kill, it does not require that the intent exists for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all of the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of the defendant in order to convict. Evidence of motive by itself does not establish guilt. You should give it the weight you believe it deserves under all of the circumstances. If you're satisfied beyond a reasonable doubt that the defendant caused the death of Sade Robinson with the intent to kill, you should find the defendant guilty of first-degree intentional homicide. If you're not so satisfied, you must find the defendant not guilty of first-degree intentional homicide, and you should consider whether the defendant is guilty of first-degree reckless homicide in violation of statutory section 940.02 sub 1, which is a lesser included offense of first-degree intentional homicide. You should make every reasonable effort to agree unanimously on the charge of first-degree intentional homicide before considering the offense of first-degree reckless homicide. However, if after full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of first-degree intentional homicide, you should consider whether the defendant is guilty of first-degree reckless homicide. Now, as I already stated, first-degree reckless homicide is defined in 940.02 sub 1 of our criminal code and is committed by one who recklessly causes the death of another human being under circumstances that show utter disregard for human life. Before you may find the defendant guilty of first-degree reckless homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. One, that the defendant caused the death of Sade Robinson. Cause means the defendant's act was a substantial factor in producing the death. Two, that the defendant caused the death by criminally reckless conduct. Criminally reckless conduct means that the conduct created a risk of death or great bodily harm to another person, and the risk of death or great bodily harm was unreasonable and substantial, and that the defendant was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. The third element is that the circumstances of the defendant's conduct showed utter disregard for human life. In determining whether the circumstances of the conduct showed utter disregard for human life, consider these factors: what the defendant was doing, why the defendant was engaged in that conduct, how dangerous the conduct was, how obvious the danger was, whether the conduct showed any regard for life, and all the other facts and circumstances relating to the conduct. Consider also the defendant's conduct after the death, to the extent that it helps you decide whether or not the circumstances showed utter disregard for human life at the time that the death occurred. If you're satisfied beyond a reasonable doubt that the defendant caused the death of Sade Robinson by criminally reckless conduct and the circumstances of the conduct showed utter disregard for human life, you should find the defendant guilty of first-degree reckless homicide. If you're not so satisfied, you must find the defendant not guilty. You are not in any event to find the defendant guilty of more than one of these offenses. Now, the second count of the information in this case charges that Maxwell Anderson, on or about Tuesday, April 2nd of 2024 in Milwaukee County, Wisconsin, did dismember a corpse with the intent to conceal a crime, contrary to Wisconsin statutes. To this charge, the defendant has also entered a plea of not guilty, which means the state must prove every element of this offense charge beyond a reasonable doubt. Section 940.11 sub 1 of our criminal code is violated by one who mutilates, disfigures, or dismembers a corpse with the intent to conceal a crime or avoid apprehension, prosecution, or conviction for a crime. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. One, that the defendant dismembered a corpse. Two, that the defendant dismembered a corpse with the intent to conceal a crime. This requires that the defendant acted with the purpose to conceal a crime. You cannot look into a person's mind to find intent. Intent must be found, if found at all, from the defendant's acts, words, statements, if any, and from all of the facts and circumstances in the case bearing upon intent. If you're satisfied beyond a reasonable doubt that both elements of this offense have been proved, you should find the defendant guilty. If you're not so satisfied, you must find the defendant not guilty. Now, the third count in the information in this case charges that Maxwell Anderson, on or about Tuesday, April 2nd of 2024, at 2926 West Lisbon Avenue in the city of Milwaukee, Milwaukee County, Wisconsin, by means of fire, did intentionally damage the property other than a building of Sade Robinson, valued at $100 or more without that person's consent, contrary to Wisconsin statutes. To this charge, again, the defendant has entered a plea of not guilty, which means the state must prove every element of this offense charge beyond a reasonable doubt. Arson is defined in 943.03 of our criminal code and is committed by one who, by means of fire, intentionally damages any property of another without that person's consent if the property is not a building and has a value of $100 or more. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following 5 elements were present. Number 1, that the defendant intentionally damaged a 2020 Honda Civic by means of fire. Damage means injured, charred, defaced, and includes smoke damage. Intentionally means that the defendant must have had the mental purpose to damage the property of another by means of fire, or was aware that his conduct was practically certain to cause the damage to the property. The second element is that the 2020 Honda Civic was the property of another. Property of another means property in which a person other than the defendant has a legal interest, which the defendant has no right to defeat or impair, even though the defendant may also have a legal interest in the property. The third element is that the defendant damaged the property by fire without the owner's consent. The fourth element is the value of the 2020 Honda Civic was $100 or more. And the fifth element is that the defendant knew that the 2020 Honda Civic belonged to another person, and that the other person did not consent to the damage of the property, and that the value of the property was $100 or more. Again, you cannot look into a person's mind to find intent and knowledge. Intent and knowledge must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all of the facts and circumstances in the case which bear upon intent and knowledge. If you're satisfied beyond a reasonable doubt that all 5 elements of this offense have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. The fourth count in the information charges that Maxwell Anderson, on or about Tuesday, April 2nd, 2024, in Milwaukee County, Wisconsin, did hide a corpse with the intent to conceal a crime contrary to Wisconsin statutes. To this charge, again, the defendant has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. Section 940.11 sub 2 of our criminal code is violated by one who hides or buries a corpse with the intent to conceal a crime. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following 2 elements were present. 1, that the defendant hid a corpse. 2, that the defendant hid a corpse with the intent to conceal a crime. Can't look into a person's mind to find intent. Intent must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all of the facts and circumstances in the case bearing upon intent. If you're satisfied beyond a reasonable doubt that both elements of this offense have been proved, you should find the defendant guilty. If you're not so satisfied, you must find the defendant not guilty. Now, evidence is, first, the sworn testimony of witnesses, both on direct and cross-examination, regardless of who calls a witness. Second, the exhibits the court receives, whether or not they go to the jury room. Third, any facts to which the lawyers have agreed or stipulated or which I've directed you to find. Anything you have seen or heard outside of this courtroom is not evidence. You are to decide this case solely on the evidence offered and received at trial. Disregard entirely any question that I did not allow to be answered. Do not guess at what a witness's answer might have been. If a question itself suggested certain information might be true, ignore the suggestion and do not even consider it as evidence. Attorneys for each side have the right and the duty to object to what they consider are improper questions asked of witnesses and to the admission of other evidence which they believe is not properly admissible. You should not draw any conclusion from the fact that an objection was made. By allowing testimony or other evidence to be received over the objection of counsel, I am not indicating any opinion about the evidence. You jurors are the judges of the credibility of the witnesses and of the weight of the evidence. During the trial, I have ordered certain testimony to be stricken. Disregard all stricken testimony. Remarks of the attorneys are not evidence. If a remark suggested certain facts not in evidence, disregard the suggestion. It is not necessary that every fact be proved directly by a witness or an exhibit. A fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that the defendant committed the offense before you may find the defendant guilty. Evidence has been presented relating to the defendant's conduct after an alleged crime was committed. Whether the evidence shows consciousness of guilt and whether consciousness of guilt shows actual guilt are matters exclusively for you to decide. The weight of evidence does not depend on the number of witnesses on each side. You may find that the testimony of one witness is entitled to greater weight than that of another witness or even of several other witnesses. In weighing the evidence, you may take into account matters of your common knowledge and your observations and experiences in the affairs of life. Ordinarily, a witness may only testify about facts. However, a witness with specialized knowledge in a particular field may give an opinion in that field. In determining the weight to give to this opinion, you should consider the qualifications and credibility of the witness, the facts upon which an opinion is based, and the reasons given for the opinion. Opinion evidence was received to help you reach a conclusion. However, you are not bound by any witness's opinion. The identification of the defendant is an issue in this case, and you should give it your careful attention. You should consider the reliability of any identification made by a witness, whether made in or out of court. You should consider the credibility of a witness making an identification of the defendant in the same way you consider credibility of any other witness. Identification evidence involves an expression of belief or impression by a witness. Its value depends on the opportunity the witness had to observe the offender at the time of the offense and later to make a reliable identification. Consider a witness's opportunity for observation, how long the observation lasted, how close a witness was, the lighting, the mental state of the witness at the time, the physical ability of the witness to see and hear events, and any other circumstances of the observation. We should also consider the period of time which elapses between a witness's observation and the identification of the defendant, and any intervening events which may have affected or influenced the identification. In evaluating the identification evidence, you are to consider those factors which might affect human perception and memory, and all the influences and circumstances relating to the identification. Then give the evidence the weight you believe it should receive. If you find that the crime alleged was committed, before you may find the defendant guilty, you must be satisfied beyond a reasonable doubt that the defendant is the person who committed the crime. Ordinarily, a witness may testify only about facts. However, in this case, Detective Casey Donahue was allowed to give an opinion as to what he heard on a video-audio recording. In determining the weight you give to this opinion, you should consider the witness's opportunity to observe what happened and the extent to which the opinion is based on that observation. Opinion evidence was received to help you reach a conclusion. However, you are not bound by the opinion of any witness. During the trial, a witness was told to assume certain facts and then was asked for an opinion based upon that assumption. This is called a hypothetical question. The opinion does not establish the truth of the facts upon which it is based. Consider the opinion only if you believe the assumed facts upon which it was based have been proved. If you find that the facts stated in the hypothetical question have not been proved, then the opinion based on those facts should not be given any weight. A defendant in a criminal case has the absolute constitutional right not to testify. The defendant's decision not to testify must not be considered by you in any way and must not influence your verdict in any manner. It is the duty of the jury to scrutinize and to weigh the testimony of witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is the believability of the witnesses and the weight to be given to their testimony. In your determination of credibility, you must avoid bias, conscious or unconscious, based on a witness's race, national origin, religion, age, ability, gender identity, sexual orientation, education, income level, or any other personal characteristic. In determining the credibility of each witness and the weight you give to the testimony of each witness, consider these factors. Whether the witness has an interest or lack of interest in the result of the trial, the witness's conduct, appearance, and demeanor on the witness stand, the clearness or the lack of clearness of the witness's recollection, the opportunity the witness had for observing and for knowing the matters the witness testified about, the reasonableness of the witness's testimony, the apparent intelligence of the witness, bias or prejudice, if any's been shown, possible motives for falsifying testimony, and all other facts and circumstances during the trial which tend either to support or to discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. There is no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things people say to you, and you should do the same thing here. In reaching your verdict, examine the evidence with care and caution. Act with judgment, reason, and prudence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty, unless in your deliberations you find it is overcome by evidence that satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you must do so and return a verdict of not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs in life. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt. You are to search for the truth. Consider carefully the closing arguments of the attorneys, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions that I have given to you. State, are you prepared to proceed?
Yes.
Please do so.
Ladies and gentlemen, at the beginning of this trial, I told you that I was going to ask you to do two things then. I'm asking you to do the same two things now, and to use your common sense and search for the truth. That is what the bulk of those instructions are telling you to do. You have heard all of the evidence in this case. You have heard from dozens of witnesses. You have seen hundreds of images, watched stacks of videos. You are fully equipped to determine what the facts are, what it is that happened on April 1st and April 2nd. All of that information has rendered you capable of rendering fair and rational verdicts. And the judge has instructed you on the law, and shortly, probably not today, but when you come back tomorrow, it's going to be your time to let your voice heard after hearing everything that you have heard. On the night of April 1st, 2024, into April 2nd, 2024, Sade Robinson was murdered. She was taken to Warnemont Park, cut into pieces, dispersed mostly into Lake Michigan, her car taken to the north side of Milwaukee, and burned behind an abandoned building at 30th and Lisbon. And the evidence in this case has shown you beyond a reasonable doubt that the individual responsible for those intentional acts is Maxwell Anderson. This is my opportunity to summarize the evidence for you, and I'm going to do it in kind of essentially the form of a timeline on the TV screen here. So we'll start out with Sade's day. And Sade Robinson, she was a 19-year-old young woman just coming into adulthood. She was anything and everything that any 19-year-old would want to be. She worked a job. She worked two jobs. She went to MATC. She was supporting herself. She had her small Lower East Side apartment, modest, and most of all, she was loved and respected by her family. She was fun, social, and clearly anybody knew her, cared about her deeply, until she came into contact with 33-year-old Maxwell Anderson. At 9 a.m., April 1st, Sade left her apartment at 1858 North Commerce Street. She is wearing the last clothes she would ever wear, that white cable knit top, the black puffy coat, the ripped jeans, and the white shoes, and she went to work at Pizza Shuttle. She arrived at Pizza Shuttle over there on North Farwell Avenue on the Lower East Side around 9:15 a.m., and she worked her shift, just like any other day of her life. Beginning around 4:15 p.m., she began texting with Maxwell Anderson. They had met the previous weekend at Victor's. You saw the video of her going into Victor's and then him walking her out. And it's clear that they were intending to meet up that night. And Maxwell Anderson says, why not Twisted Fisherman? And this text conversation begins around 4:15 p.m. and they agree to meet there shortly after 5 p.m. We know from the cellular records where each of them are at those times. Maxwell Anderson is over at his house on South 39th Street, and Sade is up here at Twisted Fisherman. When her shift is over, she goes to meet him at the Twisted Fisherman. Maxwell Anderson takes an Uber ride. Sade leaves work at 5, and the phone information shows them both moving towards the Twisted Fisherman right around the same time. And we know that Maxwell Anderson walks in to the Twisted Fisherman at 5:09 p.m. wearing that black Carhartt shirt that would later be found in his laundry, and the red plaid jacket that police found inside Maxwell Anderson's house that you know has Sade Robinson's DNA on it and Maxwell Anderson's DNA on it. 5:11, 2 minutes after he gets there, he sits down at the bar, he sends a text to Sade, just got to Twisted. Sade arrives around 5:20. We know that from about 5:20 p.m. to 6:24 p.m., the two of them sit at Twisted Fisherman. They eat, they have some drinks. They both take shots. In fact, at one point, Sade turns down a shot, but they're just hanging out. And after 6:24 p.m., the two of them leave Twisted Fisherman together. They walk out and they walk together to Sade Robinson's 2020 Honda Civic that she has driven there. Sade drives the two of them from Twisted Fisherman to Dukes on Water. We know they traveled to Dukes on Water between 6:24 p.m., arriving there just around 6:33 p.m., and you saw the video of them parking. Sade, again, driving, Maxwell Anderson riding passenger, just the two of them. They walk into Dukes on Water at 6:36 p.m., consistent with the phone information showing them arrive at Dukes on Water at 6:36 p.m. At 9:03 p.m., actually, I'll go back up. They stay there. They hang out right here. Maxwell Anderson is drinking. He's having multiple drinks. Sade's got a couple drinks. Mr. Anderson takes it upon himself to play a few games of bar dice, and he takes several shots. But at no point at any time when they're at Twisted Fisherman or Dukes on Water is Sade Robinson doing anything that comes close to excessive drinking or anything like that. In fact, when you watch her on these videos, she is totally coherent. She has her wits about her. When they leave at 9:03 p.m., she's fine. They walk out together. She's not stumbling. She's totally fine. They walk together to her car. She gets in the driver's seat, and he gets in the passenger seat, and it's just the two of them who leave the bar together. And ladies and gentlemen, this video right here that's playing on the screen and the surrounding videos that watch Sade going into her car, this is the last time Sade Robinson was in public with anybody else. That young lady who's in Dukes, who she gives a hug to at the end of the night when they're leaving, that's the last person other than the defendant who she was with, who she had contact with. That's what the evidence shows. After this time, they leave, and we know exactly what route they took. Through the videos from downtown, they drove Sade Robinson driving, Mr. Anderson riding passenger. They take McKinley up. They get on the interstate. They drive to the south side. This is occurring from 9:04 to 9:14 p.m. By 9:14 to 9:25, they're getting off the interstate, heading westbound on Morgan Avenue. It's the Holt Avenue exit, but it's Morgan Avenue to the west of the interstate. And they go and they arrive at his residence just around 9:20 to 9:25 p.m. That's what the phone records confirm, and that is what the videos, here's one of them from around Sade's residence, show as well. You had the videos of them pulling into the alley. All of this confirming, by the way, that Sade Robinson's phone is essentially wherever her car is that night, right? It's at Pizza Shuttle when she's working, it's at Twisted Fisherman when she's there, and it goes back to her with Maxwell and Anderson after they leave Duke's. And they don't stop anywhere. Remember that. When they leave Duke's, they don't stop anywhere. It's a continuous trip on that Life 360 app from Duke's to Mr. Anderson's home, and they arrive there at 9:20 p.m. And we know that after 9:20 p.m., 9:23, this is that really small video that shows them coming into his backyard at 9:24 p.m. She has parked her car in the alley, just the two of them, and they come inside at 9:24. And by 9:25 p.m., they are upstairs. That motion light is on. And you heard from the detective who watched this video for hundreds of hours. You saw a lot of the clips from here overnight, some of them pretty cumbersome, but what did that establish that happened? It established that they were both there in Maxwell Anderson's apartment, and there is constant movement coming from that upstairs front window, starting at 9:25 p.m. when they're up there and going essentially on and off all the way up until 12:45 a.m., at which time all movement at that house, in that front window, and in that backyard by that back gate stops. What else happens in that time? You see movement beginning at 11:24 p.m. in the side yard. Here's the slide that shows their phones remaining there, corroborating what the video shows of her car arriving there as well. At 11:25 p.m., we see that movement in the side yard beginning. Then there's movement again after 11:25 p.m. on and off in that above front room. 12:05 to 12:08 a.m., what do we know is happening? We know that Maxwell Anderson is on his phone, traversing his photo gallery, where he has, by 12:05, already acquired pictures, already taken pictures of Sade Robinson incapacitated on his couch. She is face down. Her face is buried in his couch cushion. He has her breast exposed, and he is grabbing her right breast, the breast that would later be cut off of her body, and pulling her pants down. And you know from the search warrant of the house, this right here is that brown ottoman. This right here is the red couch. Between the movement in that front window and these photographs, you know that Sade Robinson became incapacitated while she was in that front room of Maxwell Anderson's house, laying on his couch, face down. She is out of it there. Out of it. He is grabbing her because he knows he can, because she's not going to do anything about it. She has no power. You can see that in those photos. Her face down in the cushions. 12:44 a.m., this is the last movement in that side yard. And if you recall, I made it a point to ask about the two blinking lights from her car, the Honda Civic. You saw it in the video from when they left Duke's on Water, and you see it in this video from across the street. It's faint, but it's there. This is the time, ladies and gentlemen, where Maxwell Anderson is removing Sade's body from his house, taking her to the car. It's now time to get rid of her, and he's got to do it in her car. He needs the car away from his home. He needs to get rid of anything that's going to tie her back to his home. He needs that car gone. He needs her gone. 12:47 a.m. is when we see the car leaving the house, going southbound, exiting onto Euclid, and from there you saw an exhausting amount of videos showing the car driving away from his house, northbound to the north side of Milwaukee. That was 12:49, 12:51, going northbound on 35th Street, passing Badger Ham, 12:53 a.m. northbound passing 35th and Greenfield. And eventually we get the exact route that is taken when we get the phone records. He drove northbound on 35th. He went to the downtown area and he ultimately exited the interstate just prior to 1:00 a.m. Remember, this timestamp was off by about 2 minutes and I thought it was 2 minutes, 40 seconds or so that the detective said. That is her car. We know it's her car because this camera happens to have a license plate reader. And that license plate reader is putting her on that exit ramp downtown at the exact same time that her phone, her Life 360 and Verizon records show that that car would be exiting at that same time. What can you conclude from that? You can conclude that her phone is in that car. She's in that car. Someone's driving that car. It's Maxwell Anderson. Continues to drive. He goes up Commerce, passes by her apartment building. I know something of defense was trying to make some note of it. They never stop at her apartment building. There's no evidence that that happened whatsoever. And the detectives reviewed hours and hours of video footage from her apartment building to ensure that that car never came back and that Sade never came back to the apartment. He didn't stop there, and these records confirm that. What does he do? He drives the car with her body. There he is at 106, driving her past Commerce Street, passing Lakefront Brewery. And then he heads into River West. You saw the video of the car in River West off of Dowsman near Pleasant Valley Park along the Milwaukee River. And what do we know happens while he's out and about driving around? His phone dies. He leaves his phone behind. That was done on purpose. Because look at all the records we have showing where her phone traveled and where his phone traveled before this time. He left it behind to cover up. That's why he did that. And we know that because we looked at it, and you heard from the analyst today who said that all activity on that cell phone stopped after 12:08 a.m., right after he's deleting pictures of Sade Robinson on his phone, of him grabbing her. Phone dies at 1:35 a.m. while he's driving her car around trying to get rid of her and trying to get rid of the car. He goes down Capitol. You saw the two videos showing the car going down Capitol. He doubles back towards the interstate. And by 2:20 to 2:25, he's back on the interstate heading back towards downtown. He eventually goes down through downtown on Interstate 94, ends up heading sort of west over to Greenfield, and then he comes back. And where do we know that he's heading at this time? He's heading to Warnemont Park. The phone records show that between 2:34 and 2:39, he's on the interstate, getting off on College Avenue. We saw the video of him exiting on College Avenue. And you saw the video of the car going through the airport tunnel in the direction of Warnemont Park. No stops being made, by the way. 2:51, he's passing by St. Luke's Hospital, going north on Lake Drive, all in an effort to ultimately end right here, Warnemont Park. Keep in mind what Agent Reinerth testified to. The 4 dwellings that Sade Robinson's Life 360 showed. There were 4 of them. Twisted Fisherman, her own work, or excuse me, Twisted Fisherman, Dukes on Water, Maxwell Anderson's house, and Warnemont Park, where she ends up. And her phone stays there for over 2.5 hours. Excuse me, an hour and a half. 2:52 is the arrival time, 4:33 a.m. That's the time the phone is there. We know at 2:52, her car is passing by the water department. And by 2:53 a.m., this was one of the first videos we saw, there's the Honda Civic going down Pulaski Avenue, going down the service road and ramming the gate to get down that service road, that steep road that you saw a photo of today when Chloe Wright was testifying. Why ram the gate? He knows how to get down there without ramming the gate. You saw a photo of the place, that the way that they would walk down. You ram the gate because there is a body in the car that you have to get rid of, that you can't carry. He rams the gate. We know it's using her car because the crime lab fitted the broken pieces of Honda back to her vehicle. No question about whose car was used to ram that gate. It was Sade Robinson's Honda Civic. From 2:52 to 4:30 a.m., like I said, the phone remains in that location. What is that location? That is Maxwell Anderson's secret beach. It's the place, of all the places in Milwaukee County to go, of all the places to go, Sade's body ends up at his secret beach. He chose that location on purpose. You heard the reasons why today. It's secluded. He didn't even want to tell Chloe Wright what the name of the place was. He wants to keep it to himself. And you've seen the photos of it. You've seen how high those cliffs are. This is the middle of the night on a Monday into a Tuesday in a rainy early April evening. No one's going to catch him in the act. It's pitch black down there. It's the perfect place in his mind to take her to accomplish this, because he knew he had work to do. He needed to cut her up and get rid of her. So he takes her to a place he knows and a place he trusts, a place he knows he's not going to get caught. You saw the videos of the person who we now know as Maxwell Anderson ascending and descending the bluffs on the north side of the pump house, the side where her leg would later be found on April 2nd, going up the exact paths that Chloe Wright told you they would take to go down there and hang out. The exact paths. This is the time, ladies and gentlemen, where he is cutting up her body. She is dead. Now it's time for him to get rid of her. So that's where he goes. He takes her to his place. You saw in the video when he's coming up the bluff at 4:26 a.m., he's down there for over an hour and a half. And in that time, you heard gruesomely all that was done to Sade. All the cutting, the blunt force trauma to her bones, all of it done to get rid of her, to make her disappear. That's what he wanted to do. That's what he tried to do. And he did it in this time frame, from about 3 a.m. when he got there to 4:30 when he left. Now is time for him to get rid of her car. So what does he do? 4:34, he drives her car out of Warnemont Park. We know he heads northbound on Lake Drive. We know that because Sade's phone is still in his car. Here's the record showing the direction of travel. From the site where the leg is found, her body is dispersed, headed northbound on Lake Drive, westbound on Howard Avenue here until the phone goes off the network. There's the video of him going by. And there's the last clip before it gets to the north side. And by 4:50 a.m., it is at 27th and Wells, where you can see the driver is a white person. You can see that in this video, and you can see how fogged up it is, and you can see how there's something covering the back window. He then drives north, circles the area of 32nd and Vliet, tries to go down this dead end near 34th and McKinley, but activates a ring light, so he decides, I got to go to a different place than this. There's no reason for him to drive down that street. Circles around until about 5:20 a.m. when he goes off camera and reappears at 6:50. And it is at this point, ladies and gentlemen, that he is in the 31st and Galena playground. This is the area where her leg is found, her left leg. That gap shows that during that time period, he went into that playground to dispose of her leg. By 7:30 a.m., you saw the video of him walking away from the burning car, where we now know from the crime lab He used an ignitable petroleum distillate to light the car on fire, and he walks away. And the trail of videos capture him walking southbound on 30th. He goes down Walnut Street. Trail of videos captures him all the way at 8:12 when he boards a Milwaukee County Transit bus, where his face is clearly visible, clear as day, and he's wearing a hoodie, that gray hoodie that would later end up in a dumpster 2 houses down from his. Tried to get rid of it, but he didn't. They found it. And whose DNA is on the hoodie? That is not the hoodie he's wearing on the date, by the way. That's the hoodie he's wearing after he has just dismembered a body and burned a car. And whose DNA is on it? His and Sade's. What are the chances of that? It's because he did it. It's because he's responsible. And he takes the bus home. He sits there, not a single time pulling out his phone. Why? Because he left it back home on purpose. And then by 8:42, walking in his back gate with that massive backpack that we have never found. He got rid of it. And whatever else was in it and whatever else was used, he tried to get rid of everything. He tried to cover up. And what does he do after he gets home? He powers up his phone and he sends a text. Morning, how's work going? Disgusting. Right after he's just burned her car, killed her. Why did he do that? He's covering up. He's trying to cover his tracks. He's trying to make sure everything seems normal. Same reason he went to work that day. Couldn't let his routine go out. He needed to maintain appearances, despite the fact that in the middle of the night, he's out cutting up a human body and burning a car. And by 5:29, Sade's leg is found on April 2nd. By 9 p.m. that day, she's reported missing and the welfare checks begin. By 1 p.m. on the 4th, Mr. Anderson's arrested. And we know that in the subsequent days and month later, April 18th, May 11th, additional body parts are found. Her head, her right breast have never been found. He succeeded in getting rid of those. That's what happened. Those are the facts. That's what the evidence showed. Now you have to decide, based on the law given to you, the crimes. I want to focus on the homicide count. There's 4 charges. Numbers 2, 3, and 4 are pretty self-explanatory, and you have them in writing. Mutilating a corpse, hiding a corpse. Counts 2 and 4 are essentially the same elements. Count 3, the arson, pretty self-explanatory. But now you're given this first-degree intentional as well as first-degree reckless homicide. First-degree intentional homicide has 2 elements that I have to prove. I have to prove that the defendant caused the death of Sade Robinson and acted with the intent to kill. While the law requires that he acted with the intent to kill, it does not require that that intent exists for any given period of time. In fact, it says it may be formed at any time before the act, including the instant before the act. And you're also instructed that intent should not be confused with motive. While proof of intent is necessary, proof of motive is not. Motive being the reason why someone did something. That's not what we have to prove. We have to prove intent. And only if you don't all agree that he is guilty of first-degree intentional homicide, which I'm confident you will, do you even look at first-degree reckless homicide. The defendant caused the death of Sade Robinson, caused the death by criminally reckless conduct under circumstances that showed utter disregard for human life. Did he show any regard for life at all? No. So how do we know this was intentional? Everything you heard shows this was intentional. Consider all the things he intentionally did and the reasonable inferences from those actions. At 9:25 p.m., when Sade drives him and herself to his house, just the two of them, they went inside, and we know from before that she is coherent. She is not drinking excessively. She's in control of herself. But by 12:05, she is completely incapacitated, face down on his couch. And Anderson is grabbing her exposed right breast with no reaction from her whatsoever. He's pulling her pants down, taking photos while doing these things. This shows she was completely incapacitated, if not deceased, by that time. Consider all the acts to this point. He has her at his house, on his furniture, completely deprived of any strength or power over herself. He's then taking pictures and then intentionally takes her car and her and drives her away because he's now got to get her out of there, and he has to separate himself from her and her car. He drives with seemingly minimal direction, leaves his phones behind, brings with him a huge bag, some kind of a tool to cut up the body, takes her to a place he knows well. All done in the middle of the night. He takes her to Warnemont Park, cuts her body up, drives away, goes to the north side, goes to the 31st and Galena playground, discards her leg. He intentionally picks an abandoned building to leave her car behind, something that he has no connection to. Intentionally stuffs her clothing that she is wearing that night. The underpants literally pulled off of her body, still in the jeans when they're found partially burned in her trunk. Stuffs her clothes in her trunk. Uses a petroleum distillate to light the car on fire. All of that stuff was done on purpose. He then heads home, powers up his phone, and texts her. Everything about this is intentional. If it was unintentional, if it was anything else, you don't cut her up and do everything you can to get rid of her. If it was an accident, you get her some help. You don't try to make her disappear. And we know from the medical examiner, there is no other explanation. There was no natural disease, no toxicology reason whatsoever for this. If it was unintentional, he wouldn't have had the wherewithal to do everything he did so quickly. Think about it. In just hours, she went from literally driving a car to being incapacitated and him somehow being able to pull off, getting her to Warnemont Park and cutting her up. He's only able to do that if he knew what he was doing, knew how he wanted to do it. This only happens with the intent to kill. Consider what Dr. Karsten today and the medical examiner talked about, the amount of work done to break her bones and cut up her limbs and cut off her head. The efforts to cover this up were extraordinary and they were horrific. Consider the cutting off of her breast, her right breast. That's not something you do unless you have a desire to do it. It doesn't facilitate getting rid of the body. It takes additional time. He did it because he wanted to do it. All the stab wounds near her breast and on her torso. That was done out of a sick desire to do harm to her. That's the only reason that is done. Cutting off the breast, dismembering limbs, beheading her. Those acts, simply put, ladies and gentlemen, are the acts of a killer. They are not the acts of someone who is acting on impulse in a moment or acting on emotion. Who does this? What kind of person cuts someone's head off? A killer. A killer who's trying to get away with killing. His actions afterwards betray any innocence. That's how the evidence shows that what Maxwell Anderson did to Sade Robinson was an intentional homicide. There is no question behind the intent, and there's no question about the person responsible for doing it. The killer is him. He's the last person to be with her, the last one texting her, the last one whose residence she was at, the last one who had her car, the last one who had her phone, the last one who was with her. The one who burned her car. He did everything he could to try to get away with it. He tried to cover up. He tried to fool the police. He's trying to fool all of you, but he doesn't get to do that. You've all seen the evidence. It's time that you let the evidence speak the truth and you find him guilty.
Defense?
I'm going to take that down then. Or just close it. Good afternoon, everyone. Wanted to start by telling you what the purpose of closing argument is. It's, of course, my chance to speak to you. This is my last chance to speak to you as jurors. I don't get a rebuttal. The state does, so they still have an opportunity to come up here and speak to you again. This is the only opportunity that I have, and so I just wanted you to be aware of that. When I got up here in opening, feels like ages ago now, it was 2 weeks ago when I stood up here and talked to all of you, and you've listened to a lot of testimony. I asked you to keep an open mind and to study the evidence closely. And I'm going to make the same request of you here today, tomorrow, when you deliberate, to study the evidence closely. You've been given a mountain of materials, and the judge has read a lot of instructions to you, and I want to talk a little bit about those instructions because as you hear Judge Crivello reading the instructions, it sort of goes on, but you're going to be given copies of those to take back with you to study closely and examine, and I ask that you look at those closely and pay careful attention to everything you heard in this case. The most important principle in the criminal justice system is the idea that a person can only be convicted if the district attorney's office has proven a case beyond a reasonable doubt. That principle has been with us for hundreds of years since the country was founded. The reason why that principle is so important is because it's crucial that when somebody is charged with the most serious of crimes, that we have absolute proof beyond a reasonable doubt by the district attorney's office, that when they decide to bring such serious charges against a person, that you are convinced beyond any reasonable doubt that, in fact, Mr. Anderson committed each one of these crimes. When Judge Crivello spoke to you, she talked about what reasonable doubt means. Reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or lack of evidence. So you can look at evidence as well as lack of evidence. It means such a doubt that would cause a person of ordinary prudence, meaning any of us, to pause or hesitate when called upon to act in the most important affairs of life. And of course, this is the most important affairs of life because you are deciding Mr. Anderson's guilt on, or whether he's not guilty on each of the counts. Another important instruction the judge had read is that each verdict, each count in this case, requires a separate analysis. And when I listened to the state's closing, I heard a lot about what their theory is with respect to intentional acts that they believe were committed after Sade passed away. I heard a lot about intentional acts that that Mr. Vance Cruzan talked about in opening and again here in closing. But I want to emphasize that when you go back to the jury room and you evaluate the evidence, you are required to evaluate each count separately. And what the judge told you, what Judge Crivello said when she read the instructions a little bit ago, is that your verdict for the crime charged in one count must not affect your verdict on any other count. Why is that important? It's important because this is a highly emotional case, obviously. We all know that. We all know that it's that type of case. And we'll just call a spade a spade. I mean, we have a victim's family sitting right here. We just heard them applause when the state finished their argument. I don't criticize them at all, what they're going through. It's not at all what I'm here to do. I can't even imagine it. Can't imagine it. But here's how the system works. We get 12 jurors together. We have 15 of you here, and you've been amazing jurors, all of you, here on time, ready to go, listen to everything. And what we try to do when we're representing somebody and representing Mr. Anderson is we try to pay attention to what's happening in court, but also all of you, because your decision is what really matters. It's not what Mr. Vance Cruzan says. It's not what I say. It's really what all of you say once you go back in that jury room and carefully consider the evidence or lack of evidence. And it's important to evaluate each one of these counts separately. And the judge told you, as hard as that can be in cases like this, to try to check your emotions at the door. I know it's hard. I don't think any of us envy any of aspect of what our jobs are. We all have a job to do. The most important job is yours, and it's to check your emotion at the door, put aside passion, put aside prejudice, and look at the case from the evidence. That's all I ask you to do. And on each count, render a separate verdict unanimously. All of you agree. And there's a number of things I could say to you. The idea here is that each side is given 45 minutes. I don't know if I need 45 minutes, when you've sat here and heard everything the same way I've heard everything and the same way the state has heard everything. We try to look at the jurors to see, some people are taking lots of notes, some people are taking less notes. And at the end of the day, really it's just what you remember and what you ask to see. That's what counts. And you can ask to see anything. You can make a request when you go back there of the judge to view videos again, if that's something that you'd like to do, or look at DNA reports or look at photographs. You can make those requests, and I would encourage you to do so. And so I'm going to touch on some of the points that I think are important. You may agree with me, disagree with me, but this is my chance to present to you what I think are the important points in Max's defense. We do have separate crimes that are charged here. Obviously, if we broke them into sort of broad categories, there's the state's theory that Max intended to kill Sade Robinson. So that seems to be the glaring charge, of course, that is here. We also have charges of dismemberment, hiding a corpse, and arson of a vehicle. I'm not going to go through each of the elements of every one of these crimes with all of you, because that will go back with you to the jury room, and you can read those and decide. But we start with the fact that everything the state showed you in this case was that Max had met Sade. You saw the videos that were just played again in closing. The two of them met each other, and the two of them went out in public. They texted, they made arrangements to go out, and they went to places. You watched the videos, they went to places that Max is known. Places where he was interacting in a friendly way with bartenders, where people were talking to him on a first name basis, where he's shaking hands with people, where he's having normal drinks, normal behavior. They go to Twisted Fisherman, they spend time there together. There's nothing in the videos that you've seen that suggests that Max is planning to do anything like an intentional homicide. There's nothing in the text messages that even comes close to suggesting that. Because of course, intent does have to be formed at some point, as they just said, and as the judge told you, before a person passes away. Nothing about the Twisted Fisherman video shows for 1 minute an intent to kill. And the same is true with Dukes. They go there, they're sitting at the edge of the bar, they're playing beer pong with another couple that shows up. Again, you can see, even if you want to watch the video again, you can see when Max leaves, he's saying goodbye to people that know him. Obviously, he used to work at Twisted Fisherman, we know, because he had to pick up his W-2 there. He's known at Dukes. So this is not any evidence at all that Max intended to kill Sade. And like many people do, they went out after drinking and they went back to his house. We asked you in jury selection, all of you, we asked the question of whether or not you would insist that a defendant testify. The defendant has a constitutional right not to. That's a hard principle for some people to embrace. You don't have to testify. The system doesn't require that. It's human nature. It's to want to hear sometimes, like we say to our children sometimes, what did you do? What happened? Give me the side of your story. But that's how we handle things in our personal lives and not what is required here in court. And I am just going to address the elephant in the room. Max didn't testify, right? We all saw that. And maybe some of you were thinking to yourselves that you wanted to hear from him. Maybe all of you were thinking that. Certainly members of the public might have been thinking that. But he's not required to do that. The judge told you that. He's not required to give any explanation or prove his innocence. System does not ever require a defendant to prove their innocence. It requires the state to prove that he intentionally killed her. I didn't see any evidence of intent when I sat through this trial. The state points out things that they say Mr. Anderson did after the fact, which would demonstrate, if he had done it, an intent to commit other crimes, mutilation of a corpse. But I didn't see anything, and I listened carefully, and I know all of you did too, that shows any intent to kill. And that's how it started, and now there's a reckless homicide charge that you're supposed to consider as well, but I didn't see or hear any testimony about Mr. Anderson acting recklessly towards Sade at all. And those elements have to be proven. It has to be proven. In words, as the jury instruction said, words, actions, behavior before the event. Well, what are they pointing to? I'm asking that question. What are they pointing to? They're pointing to things afterwards that they say Mr. Anderson did, which they want you to bootstrap into a conviction on an intentional homicide. But that's not what the law says you're supposed to do. The law says you're supposed to look at each count separately. The law says that a defendant doesn't have to prove his innocence. The law says that they have to prove intent or recklessness beyond a reasonable doubt. The highest possible burden you could imagine. Not just that we think he might have done it, or last person with her could have done it, but that he intended to do it, or that he did it recklessly. And I don't know, based on this record, candidly, how she died. I don't know that any of us do. The medical examiner doesn't. Medical examiner is unable to tell us that answer. It's their job. Certainly the anthropologist we heard from doesn't know. And I talked about this with all of you in opening, that they have the burden to prove everything beyond a reasonable doubt. And if they don't, we don't have to put on any evidence. We don't have to put Max on the stand. We don't have to call witnesses to say A, B, and C. And I told you in opening, we weren't going to dispute, I forget what I said exactly, but I probably said we won't dispute 90+% of the case, because we don't. Everything Mr. Vance Curzan just showed you about the vehicle traveling to these locations, we dispute the big things, that it's Mr. Anderson intending to kill her or recklessly kill her. We dispute that he committed the other crimes, but the fact that they went on a date, the fact that they were together, the fact that they were friendly with each other, they drank, no dispute. The vehicle being shown on camera all over the place, the locations it went, no dispute. What we do dispute are a number of important points that I don't think have been proven. You never once see Max getting into this Honda Civic. Nor do you see him getting out of the Honda Civic. You don't see him get in and you don't see him get out. And there was a video that was played very early on in the trial that all of you will remember because it was day 1 or day 2, but there was a video of the Honda Civic when it is in flames, basically on Lisbon Avenue, if we all remember that. And there's 2 women on the street who are on tape pointing in that direction. And you can obviously see that Max is in that area. I told you in opening, sometimes people can be in the wrong place at the wrong time. I don't have to prove, I have no burden to prove why Max was in that area. That is burden shifting, is not required. They have to prove that he was the one that exited the driver's door of that car and lit it on fire. They did not call either of those women in their case. They could have chosen to call either of those 2 women on the street and put them on the stand and say, is that the guy who lit the car or is that the guy walking near the car? Big difference. They could have asked him any question they wanted. Of course, we would have been able to ask questions too, but they could have put, her name is Laura Dyer, you heard that through other witnesses. They could have put Laura Dyer on the stand and asked her, who were you pointing to? What were you seeing? What did you observe in the minutes leading up to that? Who got out of the car? What side did they get out of, ma'am? What side did they get out of? If they got out of the car, how did they light the car on fire? They could have asked all of those questions and answered all of those questions for you. And we know for sure that she was shown a photo array because I asked one of the detectives about the photo array procedure. We know for sure it was shown and they didn't introduce it. I'm not here to hide a thing. Study it all. Study every piece of evidence that they gave you in this case. But they didn't call Laura Dyer, who I would argue would be the one witness you would call in your case to, if you wanted to prove that Max lit that car on fire, instead of being near it. And if we work from there forward, if we look at his behavior afterwards, Max's behavior, it's Max there, his behavior afterwards, they haven't proven what was in his backpack. But if we look at his behavior afterwards, he is not, as they just said, concealing his identity. Now, if you lit a car on fire, there's 4 ways you can go, north, south, east, or west. And I would argue that the last direction you would go is right down to Lisbon Avenue if you did that, onto a public street with cars whizzing by and buzzes everywhere and getting on a public bus. Actually, if you looked at the video, there's an alley right there. The more logical way to go is just dart up through that alley, get away, duck through houses and backyards and run. Max is walking. But look at his shoes. Because their theory that they've given you in this case is that Max, prior to this, first of all, their theory is he killed her in his house without Pete Warburton hearing a thing, who's right below him. No struggle, no stabbing, no nothing, no help, nothing. But their theory is he killed her there. But then in the rainy day, pouring rain for days, muddy path down to Warnemont Beach, their theory is that Max did all of that. Why on earth, when he is walking on Lisbon Avenue, and you can watch the videos, look at the shoes. They're pure white soles. At least the sides, even the detectives testified to that. His shoes are white. Somebody who has been trudging through the mud, dispersing body parts in Warnemont Park in the pouring rain, in the bad conditions, does not have white shoes. No way. Muddy shoes, for sure. Watch the whole bus video. He doesn't, as they said, he doesn't pull out a phone or he sits there the whole time. Shoes are white. That is inconsistent with somebody having been at Warnemont Beach earlier and doing all of these things just a few hours earlier that they say. The sweatshirt that was located in the trash can, we had some testimony a few days about that. I don't know what to make of that. I don't know if it was planted. I don't know how that sweatshirt got in that trash can. But I know that if somebody was trying to destroy evidence, they could burn it right in the backyard. There's a burn pit right there, and they would be unlikely to ditch it right in the alley 2 houses down from them. Seems like a really unlikely thing to do. But what you didn't hear about the sweatshirt, and we know it's found on April 12th. After Max has been arrested, he was arrested on April 4th. So 8 days later, they find this sweatshirt. And how on earth is a detective, I think it was Lopez, how on earth is a detective on April 8th, he told you his job was to go down this alley to look in the trash cans. Remember, he was going to go look for clothes or evidence. If you were going down an alley to look for clothes or evidence, and he's now telling you, I remember seeing a sweatshirt in a trash can, but I just left it there. His job was to look for a sweatshirt or any clothes. I just find it really hard to believe. I think he's not being honest when he says that. I find it really hard to believe that if you found a sweatshirt in a trash can when that was your job to go the alley behind Max's home, you would grab it. And the trash came through on April 8th. Max is in jail. And there is none of Sade's blood on that sweatshirt. We were just told, again, he's wearing that sweatshirt supposedly when he dismembered a human corpse. The amount of blood and bodily fluid that would require, look at the video of him on the bus. If you can see a speck, there's no gloves on him. There are gloves at Warnemont Beach, which exclude him, but there's no blood on him at all. There's nothing on his hands. He's not wearing gloves. Max's DNA is also not on the driver's door of Sade's car, which is lit on fire, but her DNA is. So if their theory is that the DNA on the car driver's door was washed off by the fire department, why is Sade's DNA there? And his isn't. It's because he didn't close the driver's door. It was in the wrong place at the wrong time. And they swabbed everything. It was really boring. Some aspects of the trial were really boring for all of us because you had to sit here and watch grainy videos of what a detective thinks they see upstairs, and you have to listen to us on our end bore you, unfortunately, at times by going through all of the DNA evidence. But for crying out loud, this was the most swabbed home I've ever seen in my life. Swabbed everything. Everything. Ask for the report. None of Sade's blood is anywhere in that home. But she's been stabbed. He doesn't have any blood on him at all for a stabbing. And they don't have any weapon that they can connect to him that he ever used for this stabbing. Or however she died, they don't know. But they do know for sure the DNA excludes him. It excludes him because her blood isn't in his home. Her DNA isn't anywhere in there. There's no smell of bleach. There's no indication he cleaned up. I would argue this does not look like a cleaned up place at all. Look at the photos. And there was a hair found on a proximal bone, one of Sade's bones, the hair that was found, and they thought for sure that's going to be Max's hair. We have a hair on a bone. I guarantee that's why they tested it. And look at the report. The hair on one of Sade's bones excluded him. Wasn't his. The video of the house, there's look at the pictures if you want to. It's grainy, it's poor quality. I also heard Rachel Smith said she spent 100 hours or whatever she said about the quantity of hours looking at video. The reality about the video is, again, we don't dispute that Max and Sade went back to his house. We don't dispute that they were there. Which silhouette is what or what it shows, your guess is as good as mine. I know that the FBI could look at it if they wanted to and was never asked of them to do that. They offer a witness with no specialized training in an effort to convict Max of homicide to say, well, I saw this silhouette and that silhouette, but they didn't do any height analysis. They didn't ask the FBI to be involved. And it doesn't show anything that we don't already agree happened. They were back together. But that front window is piled full of plants and other debris and miscellaneous things in there. So it's unlikely that there's really a whole lot of interaction you can truly see. It's probably dogs run around. I don't think Max is so sophisticated of a guy. I'm representing him. We heard from Pete Warbington. I don't know that Max is the most sophisticated guy out here. He's a smart guy, but he's working 3 days a week. He's a bartender. And Pete Warbington says, I complain about a hydraulic arm. He won't fix it. And Max doesn't like hearing that he's a bad landlord. I know. But the reality is that he's not a highly sophisticated guy where they introduced all sorts of evidence of his planning and research on wanting to kill someone. 30-some years living in the area, working for a decade as a bartender, well-known throughout the city. They didn't introduce one weird thing about him. No psychological profile evidence to show you that he fits the pattern of someone who's going to just decide, I'm going to kill someone tonight after a date where I went everywhere that everybody knows me, and I've never researched it, and I've never looked into it, nor have I even so much as looked at how to dispose of a body or remove body parts, which you can only imagine what kind of feat that is. Use your common knowledge of even examples you can think of cooking about how hard it might be at Thanksgiving to remove a turkey leg, let alone a human. No research on it, no planning on it at all. Again, that's because he didn't have any such plan to do anything like that. It's not that secret of a beach either, if I can just say that. I mean, a few hours after someone is down there in the rain and the horrible conditions, there's 2 kids there a few hours later in that same spot, right? They're there. They find a bone or a leg. So it's not that secret. It's Warnemont Park. It's a public park, 18-hole golf course. Everybody in the community is familiar with that area. Officer DeSmet testified, very familiar with the park. People go there all the time. We have 2 youngsters there right away a few hours later finding human remains. So not exactly a secret area that nobody's ever heard of before. What is Max's behavior afterwards? A lot of times in our human affairs, and Judge State has told you, use your common sense. The reason they keep saying common sense, and again, I didn't tell you not to use common sense. I talked about this in opening. Go ahead and use it. Use it galore. But also, please look at the evidence. You have to do more than just base things on this expression, common sense, okay? Look at the evidence. We do know that somebody who committed a crime like this, who had done something like this, when they haven't, would be highly likely to change something about their life. He didn't do any such thing. He continued to go about his day-to-day affairs. You heard that he went to work at Dugout 54 the next morning, and his phone died, not turned off intentionally. It died during the hours that one would be asleep. And he went to Dugout 54, and he worked at Dugout 54, which was his job, the next day. No issue. You didn't hear from one person who said that suddenly his behavior was different or that he started acting strange. He continued to work, stay in the area, didn't cut his hair, didn't change his appearance, didn't have a whole pile of cash in his car with a passport to Mexico, none of that. Just going about his day-to-day affairs. That's because he's innocent. And the police are the ones who make a decision on what to collect and what not to collect. And they give you that evidence, and then you decide whether it is proof beyond a reasonable doubt. They could have asked for more footage if they wanted to see what was going on the side of Max's house in the days after, or the alley in the days after. Does he ditch a sweatshirt in a trash can? But they chose not to, because they zeroed in on him, they zeroed in on a time frame, and that was all they needed to do. I know that when the evidence shows that when Sade's car left Max's house, and you never see him driving that car, when it left that house, and we know things can happen in an alley, when the car left that home, it went straight to Sade Robinson's apartment building. I never said it went there, to be clear. I never said she went in there. I'm just saying, what are the odds that with no evidence he even knew where she lived, that Civic goes from his home right past the building she lives in? A hell of a coincidence. I think it's very likely that perhaps something happened to her in the alley, and perhaps she was driving them where to go. I don't know, but I do know maybe it was a stalker. But whoever did it obviously had an idea where she lived, because they went right from point A to point B. I think the reason that the state spent such little time talking about the DNA evidence for you is because they know how powerful it is for the defense case. But we don't have to prove that DNA proves proof his innocence. They have to prove beyond a reasonable doubt that he's guilty of each of these crimes, that he intended to kill her. Now they're saying recklessly, but either one, whichever one they're saying. They had to form that intent or that reckless decision before. There's no evidence, by the way, of any reckless behavior at all that they've shown you on video, that they've shown in his house, that they've shown at all. But the reason why they spend so little time on DNA, and they sort of brushed past that, and yet they'll spend days and days and days going through monotonous video of things we don't dispute, is because they know that the DNA evidence is powerful for us. And I ask that you look at the evidence closely. That's all I can do. I turn Max over to you. It's your decision. You have to look at each count carefully, and I'm convinced you'll conclude that the state hasn't met its burden of proof on each count. Thank you.
State, any rebuttal?
Sure. Ladies and gentlemen, the reason Maxwell Anderson went to work the next day and didn't cut his hair or do any of that stuff is because he thought he got away with it. Because he did it alone. He did it in the middle of the night. So leaving town, doing that stuff, that brings attention to yourself. That's also why he sends that text message to her the next morning. Hey, morning, how's work going? He's trying to cover up. He thought he was going to get away with it. That's the whole point. Because everything he did the night of this incident was done in the middle of the night in a secluded place that he knew was secluded, that he took her to and cut her up. He thought he got away with it. Let's talk about blood. You saw the images of her on that couch. She's out of it. She is gone. There's no blood in there. You heard from the medical examiner how people can die without blood. Strangulation, suffocation. It's no coincidence that she is face down in his cushions in those. That she is so out of it that he's able to lift her shirt up and grab her breast and yank her pants off without her putting up a struggle. We know as well that the dismemberment, remember the medical examiner talking about the vital reactions, that there were no vital reactions at the areas of amputation. That means no bleeding, because she was dead when it happened. And he's doing it down at the lakefront on the shores of a lake on a rainy night. And he talks about no mud, no blood on the shoes or anything like that. He's got this massive backpack with him that he gets rid of, that has never been found. Why? If that backpack is something that's important enough for you to go out in the middle of the night with, why is it gone? Because he got rid of it. He got rid of it to cover up the crime. The hoodie, why is it in someone else's dumpster? Why is the hoodie not a hoodie you were wearing while on the date, but a hoodie you're driving around in the middle of the night with? Why is it in a dumpster 2 houses down? Why is her DNA on it? It's because he's the one driving her car around, taking her body to Warnemont Park. No intent to kill? What about all the horrible, disgusting, gruesome things that he did to her body? That shows intent to kill. He brought up this hair on the proximal bone, and his argument was Max was excluded from that hair. Do you remember whose hair that was? It was Sade's hair. He failed to mention that part just now. Just like he failed to bring up the latex gloves he brought up in his opening and said, certainly these gloves played a role in this crime. That was a quote. What a joke. Those gloves had nothing to do with this crime. Nothing. The blood on those gloves was neither Max nor Sade's. It's located a quarter-mile south of where this occurred. A week later, a smoke screen. Nothing to do with this crime. Maxwell Anderson was not walking away from the Honda Civic because he's in the wrong place at the wrong time. Why on earth is he walking around behind an abandoned building where the woman who he was on a date with the night before his car is getting set into flames and he's just casually walking away? And you did hear from the woman who saw him do it. You heard her on the video. You saw her point to him and say, he did it. Call the fire department. What's that all about? It's because he's the one who lit the car on fire to cover up all of this and calmly walk away because he's trying to get away. He's trying not to draw attention to himself. Asking you to completely speculate that something happened to her in the alley. Well, let me ask you this. How does she get in the alley if she's passed out of it, incapacitated on his couch? How would she have even gotten there? He's asking you to speculate. She's just instructed you, you can't speculate. You are not to speculate. That's what he wants you to do. That's what he wants you to do to find Maxwell Anderson not guilty, but you can't. You follow the evidence. Not a single piece of evidence points to anybody else. Everything at every single turn, even when police tried to focus on other things, like the latex glove, did it lead anywhere else except back to him? The broken pieces of car at the gate just happened to match the Honda that he's walking away from as it lights on fire. The beach where she is cut up, it's his beach. It's his place. Every single lead, every single thing the investigators did led back to Maxwell Anderson, and it is because Maxwell Anderson is the killer. He is responsible, so find him guilty.
Now, members of the jury, the duties of counsel in the court have been performed. The case has been argued by counsel. I've instructed you regarding the rules of law which should govern you in your deliberations. The time has now come when the great burden of reaching a just, fair, and conscientious decision of the case is to be thrown wholly upon you, the jurors selected for this important duty. You will not be swayed by sympathy, passion, or prejudice. You will be careful and deliberate in weighing the evidence. I charge you to keep your duties steadfastly in mind and as upright citizens to render a just and true verdict. You are to decide only whether the defendant is guilty or not guilty of the offenses charged. Any consequence of your verdicts are matters for me alone to decide and must not affect your deliberations. There will be 9 forms of verdict submitted to you regarding the charges against the defendant. As to count 1, there will be 3 verdicts. The first verdict reads, "We, the jury, find Maxwell Anderson guilty of first-degree intentional homicide as charged in count 1." Another reading is, "We, the jury, find the defendant Maxwell Anderson guilty of first-degree reckless homicide in violation of section 940.02 sub 1 of the Criminal Code of Wisconsin at the time and place charged in count 1 of the information." And a third reading, "We, the jury, find the defendant Maxwell Anderson not guilty." As to count 2, there are 2 verdicts. "We, the jury, find the defendant Maxwell Anderson guilty of mutilating a corpse as charged in count 2. Another reading, "We, the jury, find the defendant Maxwell Anderson not guilty of mutilating a corpse as charged in count 2. As to count 3, there's 2 verdicts. "We, the jury, find the defendant Maxwell Anderson guilty of arson of property other than a building as charged in count 3 of the information." Another reading, "We, the jury, find the defendant Maxwell Anderson not guilty of arson of property other than a building as charged in count 3 of the information." Lastly, as to count 4, there's 2 verdicts. "We, the jury, find the defendant guilty of hiding a corpse as charged in count 4. And another reading, "We, the jury, find the defendant not guilty of hiding a corpse as charged in count 4. You are to bring in 1 verdict per count. It is for you to determine whether the defendant is guilty or not guilty of each of the offenses charged. You must make a finding as to each count in the information. Each count carries a separate crime, and you must consider each one separately. Your verdict for the crime charged in one count must not affect your verdict on any other count. Now, this is a criminal, not a civil matter. Therefore, before the jury may return a verdict that lawfully may be received, the verdict must be reached unanimously. In a criminal case, all 12 jurors must agree in order to arrive at a legal verdict. When you retire to the jury room, select one of your members to preside over your deliberations. The presiding juror's vote is entitled to no greater weight than that of any other jurors. If you need to communicate with me while you're deliberating, have the presiding juror send a note, time-stamped and signed by the presiding juror with your question. It may take some time to answer because I may consult with the attorneys before I respond, so you should continue your deliberations while you're waiting for a response. I will answer all of your questions either in writing, or I'll bring you back into the courtroom and answer them on open record. When you've agreed upon your verdict, have it signed and dated by the presiding juror. Notify my bailiffs that a verdict has been reached. Everyone will return to the courtroom and your verdict will be read into the record in open court. I may ask each of you if you agree with the verdict. It's 4:37. I think we'll begin the deliberations. Okay. At this point, we're going to select our 2 alternates. So, 3 alternates. So all of your numbers are inside of this box. Juror number
53.
Who's 53? Okay, your first alternate.
38.
Second alternate.
And the last one, 26.
Okay, the 3 of you are my alternates. So at this point, your service is complete for the next 4 years. If you need a notice for your employment that you've been here with us, you'll have to go back to jury management to get that. Otherwise, it'll come out to you in the mail in about 2 to 3 days. Now, you're not allowed to speak to any of the other jurors, but after you leave here, you're free to speak to anyone that you wish or to no one. It is completely up to you. If you wish to return to the courtroom and wait for the verdict, you're welcome to. If you want to call my court at a later point and find out what happened, you're welcome to as well. Or you're welcome to check CCAP. Now, do the 3 of you have anything in my jury room? Okay, I need to release the 3 of you before I release the other jurors. So thank you for your time and attention and service. I've used alternates way too often, so I appreciate you being here. You're not allowed to communicate with the other jurors at this time. At this point, we will swear the bailiffs.
Do you solemnly swear that you will keep jurors on this trial together in some private place and that you will not, before they render their verdict, communicate the state of their deliberations or the verdict they have agreed upon? So help you God? I do. Thank you. Okay, you may begin your deliberations. Any objection as to how the jury instructions were read into the record, state? No. Defense?
No.
I did find on the jury instructions one correction, which was on the last page relative to the verdicts. It said 4 verdicts will be provided. I changed it to 9, and I just wrote it on it. So that was the only modification I made. I plan on recalling the jury at about 3 minutes to 5 if we don't have something happen quickly. So please, if you could stick around, I'd appreciate it. Also, if you could go through the list of exhibits and see if there's anything, if there's a request you're willing to send back without further discussion, and a stack of course, anything that you wish to be addressed on. Of course, no videos would ever be sent back or physical evidence without the bailiffs. Case was well tried. Thank you, everybody.